Ready.
All right, thank you, Ms. Strong. Let's see now. Okay, good morning, ladies and gentlemen. My name is Judge Law, and we are going to begin with our state all-purpose calendar, which is a list of criminal misdemeanor cases in which individual defendants' cases have already been formally accused by the prosecutor, who is the Solicitor General of Fulton County. Today, we are going to get a status of these cases in order to determine how the defendant would like to move forward with his or her case. The prosecution have provided defense counsel or the defendants with a recommendation if the defendant would like to accept a plea offer and plead guilty or no contest to the charges and be sentenced today. In that case, we would have a plea hearing. Otherwise, the defendant also has a right to plead not guilty and have the case further noticed for trial after the case is arraigned. Other matters we may also be addressing this morning are bond modifications, if any, as well as bench warrants and motions to set aside those warrants. So let's begin. For those who are defendants, either at Fulton County Jail or any other location, please remember that when I'm addressing your case, you have the right to remain silent. Anything that you say in open court, especially this virtual proceeding that's not only being recorded but live streamed. So please remember to exercise your right to remain silent, because anything you say can and will be used against you in the treatment of your case. If you have any questions or comments, wait till you have a chance to speak with your attorney instead of incriminating yourself. You have a right to an attorney. If you cannot afford one, one will be appointed to represent you either from the Public Defender's Office or from our conflict defense list. Now, the individuals who should have their videos on would be the courthouse staff, the courtrooms, and individuals who are attorneys. If you are a victim, a family member who's here to participate, an interested party wants to speak in a particular case, please switch your video off and mute your screen. You unmute, start your video when you hear the defendant whom you're interested in addressing is called to the floor. All right? Presently, iPhone, the lady in the blue shirt, please switch your video off, or the host can do that for me. All right, courtroom 2, shall I begin with ACDC?
Yes, good morning, Judge Law. I hope you're doing well. We're going to start here at ACDC with position number 22. Hogan.
Okay. This is Kiwanika Hogan, accused of criminal trespass causing damage to property. Case number 24CR6315G. Ms. Hogan, you've been advised of your rights, and your attorney is Ms. Kim. Ms. Kim, I'm so sorry, I didn't print your email, but if you can tell me how your client would like to proceed. Please unmute courtroom 2.
Waiver of appearance not guilty, please.
All right. Ms. Hogan, your attorney, Ms. Kim, is filing a waiver of arraignment, which means that she's entering a not guilty plea on your behalf, and your case is going to be further noticed for trial. Anything else to add?
Nothing further, Your Honor.
All right, thank you. That concludes this case.
Thank you.
Next, Judge number 26, Johnson.
Courtney Johnson, accused of disorderly conduct, striking a fixed object and driving while license suspended or revoked, 24CR6455D. Ms. Johnson, you've been advised of your rights, and your attorney is Ms. Kim. Ms. Kim, how are you proceeding?
Waiver of arraignment not guilty, Your Honor.
All right, Ms. Johnson, your attorney, Ms. Kim, is entering a not guilty plea on your behalf and waiving arraignment. Your case is going to be further noticed for trial. Thank you.
Number 39, Sanders.
Ms. Kim, are you the only PD today?
No, actually, Mr. Tom White is here and Paul Mattels are here as well.
I don't see, did you send announcements for everybody? I apologize, Judge Long.
Oh, I'll forward it again. Miss.
Please, thank you.
Absolutely. Thank you.
Have Shaquandra Sanders at ACDC, case 23 CR 7044F, accused of battery, family violence, and cruelty in the third degree. Ms. Sanders, you've been advised of your rights, and your attorney is Ms. Kim. Ms. Kim, your announcement?
Not guilty, Your Honor, waiver of arraignment, Your Honor. She also would like to know if we can argue for bond reduction. Right now, she has a $6,000 surety bond, and she really needs to reduce it to $1,000 surety bond.
Right. This is position 39. And what is the reasons for the modification? I'm assuming this bond was set at the first appearance?
Yes, Your Honor. Well, she has 4 minor children that she really needs to take care of, Your Honor. And she is she's not guilty. She does not understand why she is actually arrested for this charge. That's what it is, Your Honor. She's been here for almost about 2 weeks, 19 days in the jail.
This was not a first appearance bond. She was given a signature bond, level 1, on November 13th of last year. She apparently, defendant, there was a bond surrender with pretrial. I'm not certain why. And she made a new bond with Freedom Rings bonding on July 16th, 2024. Failed to appear before Judge Richardson on September 9, and her surety bond was forfeited. So pre-trial is Ms. Tyson. Ms. Tyson, if you have position 39 available.
Yeah, sure. And I'm checking right now.
Also, Judge, she's position number 40 as well.
Which would be the failure to appear. Okay.
She claims that she never got the notice of hearing.
Oh, that's Judge Richardson's appearance, so let me just check and see what the notice is like, but I'm more curious about why she lost her signature bond.
It looks like she has another case, Your Honor, 24 CR 004566F.
Right?
And that's for battery, family violence, first offense, cruelty to children in the third degree, and that's 2 counts. So it looks like that may have been why the case that's on this calendar
Okay.
was revoked.
And what's the incident date for 566F?
Let's see.
Because for some reason I can't open it on my end.
July 9th of 2024. And then the case that's on the calendar, arrest date was November 12th of 2023.
Okay.
Yep, so it's a new case.
July 9th. Okay. So she lost her signature bond on July 10th as a result of the new arrest. She made a new bond. And what is her current address? I have a United Avenue location. And I don't have a return to sender.
Actually, her current address is 852 United Avenue, Atlanta, Georgia, apartment number B as a boy.
Yeah, that's what we have. I just don't read out the whole address unless there's a purpose.
Oh, I apologize.
But I just don't see a return to sender. All right. Anything else, Miss Kim?
No, nothing further.
Miss Mokeke, anything else to add in this case?
No, we would just ask that the FTA be returned to Judge Richardson's courtroom to let him deal with it.
Well, it's not a question of dealing with it. I just don't think Miss Sanders qualifies for a signature bond. This is a second arrest for a domestic violence matter within less than a year. So given these current situation, she doesn't qualify for modification. Thank you.
Thank you.
Next court date will be with Judge Richardson. Next case, please.
Number 11, Cheese Quantavious.
11, okay.
You know what, Judge? I don't see Miss McLeod's case, so she's not signed on yet.
No, no. Do you have a Dennis Murphy case by any chance? Because I know Mr. Murphy was here. No, he's not here right now. Okay, we can move on.
The other cases that I have, it's two of my other cases are for Miss McLeod, and then I have Reed LeVar, position number 8 add-on. He's for another, who's the attorney? Carrington?
Yeah, Miss Casey Strong, can you confirm? I got an email that Mr. Carrington Matthews has got a conflict for today.
Yes, ma'am, that's correct.
All right, and that was on our add-on, correct?
Excuse me, Your Honor.
Yes, Ms. Deputy Milton.
Teresa, who works with him, she's gonna be logging on in 15 minutes.
Who is this?
Teresa, she works for Attorney Matthews.
Okay. Well, all right, what's her last name again?
I don't know her last name. Her first name is Teresa.
Teresa? Okay. All right, we'll wait for Miss Teresa to come and address Mr. LeVar Reed's case. Meanwhile, Ms. Mukeke, has that case been transferred to the present time? To the DA's office?
Let me take a look at that, Your Honor.
This is position 8 on the add-on calendar.
Miss McLeod.
All right, so Deputy Francois, you just have Mr. LeVar Reed and 2 cases with Ms. McLeod, is that correct?
That is correct, Judge. You can go to courtroom 2. Thank you.
All right, thank you. Courtroom 2, who would we like to address first?
We can go to position number 29, Mr. Kendrick.
I'm sorry, Judge Law.
Yeah,
Ms. Lewis just let me know that all the cases that are Ms. McLeod's, which are on the add-on calendar, are all reset for Tuesday's SAP calendar.
Was all reset from Tuesday SAP calendar.
Oh, they were reset from Tuesday.
Yeah,
to
Judge
today.
reset it.
Oh, okay,
She was on there.
okay. Well, I'm sorry, I misunderstood. So give me a moment. I'll reach out to Ms. McLeod. I'm sorry.
no problem. All right, so position 29, is that correct? Okay, we have Bobby Kendrick accused of disorderly conduct and criminal trespass, 24 CR 6266C. From Mr. Kendrick, you've been advised of your rights and your attorney is Ms. Kim.
Yes, Your Honor.
How are we proceeding?
Plea, Your Honor.
All right. Mr. Kendrick, please raise your right hand. Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yes,
Ms. Mukeke, what's the recommendation for Mr. Kendrick?
Yes, Your Honor. The recommendation for count 1 disorderly conduct is 12 months to serve 60 days, credit for time served 15 days, balance probated, stay away from the Rolling Bends apartment complex located at 2500 Center Street, Northwest Atlanta. No further contact with any employees at the location, an MHET or an ADET, which I will let PD Kim decide which one is more appropriate for him, because I'm not sure if his behavior is caused by a mental health condition or an alcohol and drug problem. For count 2, the criminal trespass is going to be 12 months to run concurrent with count 1. And I would ask the defense to stipulate to venue, factual basis, and identification.
We would like to request for actually BHET, Your Honor.
Okay. And your client understands that if he decides to accept this plea, he has 15 more days to serve at the jail before he before he goes on probation.
Yes, Your Honor.
All right. Mr. Kendrick, have you consumed any medicine or alcohol?
no, ma'am.
And have you understood what's going on in your case so far?
Yes, ma'am.
Are you satisfied with your legal services?
Yes, ma'am.
And are you entering this plea willingly, knowingly, and voluntarily?
Yes, ma'am.
If you decide to accept this plea offer and enter a guilty plea, you would have to give up your constitutional right to a trial before a judge or a jury. You will not have the opportunity to go back to court to address and confront your accuser, to challenge the evidence brought before you, to present your own defenses, and have the state prove the charge against you beyond a reasonable doubt. Are you prepared to give up these rights?
Yes, ma'am.
How do you plead to disorderly conduct and criminal trespass from September 4th, 2024?
Guilty.
On the disorderly conduct, your sentence is 12 months to serve 60 days, credit for time served 15 days. With the 2-for-1 that the sheriff of Fulton County provides you, you have 15 more days to serve at the Fulton County Jail before you are released. Once you're released, you're required to report to the Fulton County Probation Office at 132 Mitchell Street in downtown Atlanta. While you are on probation, you will undergo a behavioral health evaluation and submit yourself to any treatment or counseling as required. You can do this with any healthcare provider, including Grady Hospital. Once you have completed the evaluation and any and all treatment that may be required, then your probation may go non-reporting. With regards to count 2, your sentence is 12 months probation concurrent with count 1. Thank you. Oh, I'm sorry, to stay away. I forgot the other part, that long paragraph. Stay away from the entire apartment complex called the Rolling Bends. And that's at 2500 Center Street in Northwest Atlanta, and not to have any contact with the employees at that location. Do you understand, sir?
Yes, ma'am.
All right, that completes the plea. Thank you.
Next, we can have position number 3, Mr. Barner.
This is State versus Dwayne Barner, 24 CR 6330H, accused of willful obstruction of an officer and criminal trespass. Mr. Barner, you've been advised of your rights, and your attorney is Mr. White. Mr. White, how are we proceeding?
So, please, Judge.
Okay. Mr. Barner, please raise your right hand. Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yes, ma'am.
Thank you. Mr. Rhodes, good morning.
Good morning. How are you doing, Judge?
Doing well, thank you.
The state's recommendation as it relates to position number 3, Mr. Bonner, is on count 1, the willful obstruction of law enforcement officers, that he received time served. 28 days in credit for time served for 14 days since September 6th of 2024. On count 2, the criminal trespass, the state is requesting 12 months to serve 28 days, credit for time served 14 days, and that the balance be on probation, and that the conditions be that he stay away from Georgia Tech's properties, and that he completes either a MHET or a BHET. Thank you, Judge.
Is that up to the defense counsel?
Yes, Your Honor, who will probably have more information than I have. So thank you, Judge.
Thank you. Mr. White, how would, well, first of all, do you stipulate to the factual basis, venue, and ID?
Stipulate, Judge.
Yes.
And we selected the behavioral health to BHET, B as in boy.
Another case?
All right. Mr. Barner, have you consumed any medicine or alcohol recently?
No, ma'am.
And have you understood what's going on in your case?
Yes, ma'am.
So if you plead guilty.
And are you satisfied with your legal services?
Yes, ma'am.
Is anybody forcing you or inducing you to take this plea offer today?
No, ma'am.
If you decide to plead guilty, you would have to give up your constitutional right to a trial in a court of law. You will not get the opportunity to go back to court to challenge the evidence brought against you, have the ability to confront your accuser, cross-examine individuals, present your own defenses and arguments, and have the state prove the charges against you beyond a reasonable doubt. Are you prepared to give up these rights?
Yes, ma'am.
How do you plead to 1 count of willful obstruction of an officer and criminal trespass?
Guilty.
On the willful obstruction, the sentence is going to be time served. To serve 28 days, credit for 14 days. So your obligation for that count is completed. For count 2, it's going to be 12 months to serve 28 days, credit for time served 14 days. To report to probation upon your release, and you would have to report on Monday, September, and that would be September 23rd, if I'm not mistaken. Yeah. Monday, September 23rd, before 3 p.m. Probation is located at 132 Mitchell Street in downtown Atlanta. While on probation, you shall stay away from all Georgia Tech property, and you will undergo a BHET within 30 days of being released, and you can do this with any qualified healthcare provider. Thank you.
Judge, we would ask the probation terminate upon completion of his requirements.
I'll amend it to non-reporting once he's completed the evaluation and as well as any and all treatment that's required.
Fair enough. Thank you, Judge.
Is that part of it? That you were like, oh, no, I'm not doing that.
Thank you.
Exactly.
Thorough. Next, we can go to position number 4, Mr. Bennett.
Correct.
Individual on the iPhone in the green jacket, are you here as a witness or a victim?
Yep. Yep.
All right.
Kim.
No, I'm
Mr. White, what position is your client?
This is position number 4, Judge, is negotiated.
Okay, Alexander Bennett is case 23 CR 5013J, accused of theft by taking from May 22nd of last year. Mr. Bennett, you've been advised of your rights and your attorney is Mr. White. May I place you under oath?
No.
Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
well.
Thank you. And Mr. Rhodes, once again, what's the recommendation?
Yes, sir. The state's recommendation as relates to the theft by taking is 12 months to serve 22 days, that he received credit for time served 11 days since August 16th of this year. And that the balance, from August 16th to August 18th, and then again from September 12th of this year. Total of 11 days. Balance be on probation, that he completes an anti-theft course, stay away from the Exxon located at 2549 Roosevelt Highway in College Park. No further contact with the victim in this case, Niraj Kadadia. And that is the state's recommendation. Thank you, Judge.
Mr. White, do you so stipulate and does your client accept these terms?
Judge, we do stipulate, and again, we would just ask the probation terminator go non-reporting once he completes his course.
Any objection to to termination, Mr. Rhodes?
Yes, Your Honor. We would rather the non-reporting for the simple fact that we still want him to, for a good bit of time, stay away from the Exxon located at 2549 Roosevelt Highway.
And Judge, the people at the Exxon could easily just give him criminal trespass warning. So, I mean,
Well, again, we would ask that it goes non-reporting so that it'll still be over his head that he needs to stay away from there at least during the term of this probation period. They shouldn't have to give him a criminal trespass warning. The condition is that he stay away, and they said it was negotiated down.
All right, thank you.
All right, let me just see. So in 2013, he was arrested for theft by taking. September 12th, he's got another case for criminal trespass and possession of a scheduled controlled substance. He's got a failure to appear and misdemeanor possession of marijuana. Does he have a hold right now in the other case, Mr. White?
I'm sorry, Judge.
Does he have a hold presently? Because it looks like he's got a bond for $7,500. He's not going to be released after this plea.
That's correct, Judge.
Okay.
10-4.
Yeah, he's going to be on continuous probation for this case. No non-reporting, no termination. All right. Mr. Barner, I'm not going to modify your probation to non-reporting or to terminate. Would you like to still proceed with this plea? Mr. Bennett, excuse me.
Judge, we want to go forward with the plea. And
All right. Mr. Bennett, have you consumed any medicine or alcohol?
No.
And have you understood what's going on in your case?
No.
This theft by taking case regarding Exxon from last year?
No.
Yes or no?
No.
Okay. And are you satisfied with your legal services?
No. Yes, ma'am.
And are you entering this plea willingly, knowingly, and voluntarily?
Yes.
Has it been explained to you that if you decide to enter a guilty plea, you would have to give up your right to a trial in front of a judge or a jury? You will not get the chance to confront your accuser, challenge the evidence that we brought against you, to be able to present your own defenses and arguments, and have the state carry its burden to prove the charge against you beyond a reasonable doubt. Are you prepared to give up these rights? No?
Um,
I'm sorry, I can't hear what you're saying. Yes or no?
Yes, I'm good. Yes.
Okay,
Yes, like 5 times, Judge. Understand.
all right. Mr. Bennett, how do you plead to one count of theft by taking at the Exxon gas station from May 22nd of 2023?
Guilty.
Your sentence is 12 months to serve 22 days, credit for time served 11 days. The remainder of the time will be placed on probation. Your probation will begin once you are released from your current hold. I understand that you do have a felony matter that you have to bond out on, so your probation won't start till you are released. Once you are released, you'll need to report to Fulton County Probation at 132 Mitchell Street in downtown Atlanta. While on probation, you will need to complete an anti-theft class, and that would have to be enrolled within 60 days of beginning your reporting. At all times, you cannot return. You have to stay 200 yards away from the Exxon gas station at 2549 Roosevelt Highway in College Park and have no contact with Niraj Kotadia. Thank you.
Thank you, Your Honor.
Just to confirm, the FTA is null pros, Mr. Rhodes?
Yeah,
Thank you.
that's position 5, and 4 was the plea. Thank you. All right, the gentleman in the white shirt, could you please switch off your video until you hear the defendant whom you address? All right. I'm sorry, Deputy Courtroom 2, who's next?
Position number 16 and 17, Mr. Green.
Okay.
Wrong way, Green.
Ms. Strong, go ahead and switch off that video. Thank you. This is Tremaine, Trimaine, Tremaine Green. He's got 22 CR 4337F, accused of criminal trespass and a bench warrant under 24 FTA 1329. Mr. Green, you've been advised of your rights. Your attorney is Mr. White. And Mr. White, is this going to be a plea?
It is a negotiated plea, Judge.
Mr. Green, please raise your right hand. Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yes, ma'am.
Mr. Rhodes?
Yes, Your Honor. As it relates to Mr. Green's case, the state is recommending 12 months to serve 16 days, credit for time served 8 days since September 12th, 2024, and that the balance be suspended in this case. Only condition is that we ask that he stay away from the enterprise at 2200 Rent-A-Car Center Parkway. That's the state recommendation. Thank you.
Mr. White, you so stipulate?
Yes, what's that?
First, I'd stay away from that. Anyway, I shop at hers.
Okay, all right. Yes, Judge, we stipulate and just ask you to accept the pleas negotiated.
So he lives nearby or he shops in that location?
No, Judge, he was talking about, he says he goes to Hertz anyway.
All right. Mr. Green, have you consumed any medicine or alcohol?
No, Your Honor.
And have you understood what's going on in your case?
Yes, ma'am, I do.
Are you satisfied with your legal services?
Yes, ma'am.
And are you entering this plea freely, willingly, and knowingly?
Willingly.
By accepting this plea offer, you would have to give up your constitutional right to a trial in front of a judge or a jury. You will not get the opportunity to confront your accuser, challenge the evidence brought against you, present your defenses and arguments, and have the state prove the charge against you beyond a reasonable doubt. Are you prepared to give up these rights? Sorry?
Yes, ma'am.
How do you plead to one count of criminal trespass?
Guilty.
Green, your sentence is 12 months to serve 16 days, credit for time served 8 days, balance suspended. You have to stay 200 yards away. That's the length of 2 football fields from the Enterprise store at 2200 Rent-A-Car Center Parkway. I guess the bench warrant is null crossed, and I don't know if there are any other holds, but that concludes this case.
Thank you, Judge.
Judge Law, we're going back to position number 22. I'm sorry, position number 26, Johnson. She's changing her plea.
Ms. Kim?
Oh, yes, she changed her mind. She would like to do a negotiated plea, Your Honor.
All right. Miss Kim, I don't know if you see the chat, but you know, Ms. Strong is sending out messages. Make sure you send all the paperwork to her. So
Thank you. I'll do that.
So we are returning back to Courtney Johnson, position 24 CR 6455D. Ms. Johnson, you've already been advised of your rights and the charges brought against you. Please raise your right hand. Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
I do.
And Ms. Mukeke, would you like to allocute the plea offer?
Yes, Your Honor. For count 1, disorderly conduct, that is going to be time served 16 days, credit for time served 8 days, and that is from September 12th, 2024 to present. For count 2, striking a fixed object, that is going to be 12 months concurrent with count 3, balance probated, and a $250 fine. For count 3, driving while license suspended, the recommendation is 12 months, served 16 days, credit for time served 8 days, balance probated, and a $500 fine.
And Ms. Kim, does your client, do you so stipulate to the terms and, I mean, to venue, ID, and factual basis? And does the client understand that her license will continue to be suspended once this conviction is posted?
Yes.
Okay. And you so stipulate, right?
Yes, Your Honor.
Okay. Ms. Johnson, have you consumed any medicine or alcohol?
No.
And have you understood what's going on in your case?
Yes.
Are you satisfied with your attorney?
Yes.
And are you entering this plea freely, willingly, and knowingly?
Yes.
So you were stopped for operating a vehicle while license suspended or revoked allegedly in February of 2023. I don't know what's the status of your driver's license today, but if you accept this plea offer, your license will be suspended for the next 4 to 6 months. So that means no driving until you apply and your license is reinstated. Are you still willing to move forward with this plea?
Yes.
Okay. I just want to make sure you understand that your license is going to be suspended again.
Your Honor, she plead NOLO, Your Honor, then maybe she can have her license.
Let me see her driving history or her driving record. Oh, Ms. Mukeke, do you have a history of her convictions?
I do have that she pled NOLO in 2019 to a driving while license suspended or revoked, so we would object to a NOLO plea.
You do it every 5 years.
We would still object.
There was 5 years ago, Your Honor.
They already ignored.
So in 2019, she pled no contest to driving while license suspended. And then 2021, 22, 3 years later, she again gets pulled over for driving while license suspended.
So she's allowed to enter a NOLO every 5 years.
And I do also see in 2023, she has a driving while license suspended or revoked and a hit and run resulting in serious injury or death. That was just an arrest, though.
What was this? Where was this, Ms. Mukeke?
He's right.
This was 2023. Let me go to that's in my notes. Let me go to her GCIC.
Okay.
That is the case, Your Honor. 2023.
And Your Honor, typically, if they're not eligible for a NOLO, PDS will just ignore the NOLO and treat it as a guilty anyway.
Mr. White, I appreciate that. You're not telling me anything we haven't been over many, many times. My question is, given her significant history and her blatant disregard of driving while license suspended, why should I accept a NOLO plea, even though she may qualify for it? And I don't see any reason for her to accept it, for her to accept this plea if I'm not willing to take a NOLO plea.
Judge, because I don't believe it's within your discretion on the statute. I think she's allowed to do one every 5 years regardless.
I respectfully disagree. So if she wants to plead NOLO, I'm not going to accept this plea. So we can move back to resetting the case for trial. Ms. Johnson, ultimately it's your decision. If you want to plead NOLO, I'm going to let you take your chances up with the state division judge, because I'm not accepting a NOLO plea when you have 2 prior cases already with driving while license suspended.
Okay.
What would you like to do?
I'll plead the guilty.
Okay. Ms. Kim, shall we proceed?
Yes, Your Honor.
As I was saying, Ms. Johnson, if you decide to plead guilty to these charges, you would have to give up your constitutional right to a trial in front of a judge or a jury. You will not get an opportunity to confront your accuser, challenge the evidence as brought before you, present your own defenses and arguments, and have the prosecutor carry its burden to prove the charges against you beyond a reasonable doubt. Are you prepared to give up these rights?
Yes.
Are you pleading freely, willingly, and knowingly?
Yes.
How do you plead to 1 count of disorderly conduct?
Guilty.
How do you plead to 1 count of striking a fixed object?
Guilty.
And how do you plead to driving while license suspended or revoked?
Guilty.
On the disorderly conduct, your sentence is time served, 16 days, credit for time served, 8 days. On count 2 is going to be 12 months probation concurrent with count 3. And for that count 2, you are to pay a fine of $250. For count 3, your sentence is 12 months to serve 16 days, credit time served 8 days, balance probated, and to pay a $500 fine. No driving unless you have a valid driver's license, adequate insurance, or proper registration. If you receive a traffic citation or if you get arrested again for any traffic incident or any criminal incident, probation is authorized to revoke this probation and have you serve out the rest of the year in prison. Do you understand?
Yes, Your Honor.
All right. You report to probation. If you have no other holds, you report to probation on Monday before 3 p.m., September 23rd, and you will report once a month, every month, until the remainder of the 11.5 months of probation is completed. And with respect to your fine of $750, you will be required to pay a minimum of $75 per month and $75 every month thereafter in order to make sure that your fine is paid off. Understood?
Yes, Your Honor.
All right. That concludes your sentence. Thank you.
Thank you, Your Honor.
Next, Judge, we have number 5 on the add-on calendar, Ms. Evans.
On the add-on calendar. Okay. Ms. McLeod, I thought I saw her. Yes. Good morning, Ms. McLeod.
Good morning, Anna. I'm here.
Okay. And at ACDC, and Mr. Murphy is here as well. So if his client is in courtroom 2, that would be great. Position 5 is Priscilla Evans, accused of battery in case 24 CR 6186A. Ms. Evans, you've been advised of your rights, and your attorney is Maureen McLeod. Ms. McLeod, it looks like your client's already posted bond with this case on September 4th, and she's actually got a parole hold at the present time. What would you like to do today?
Your Honor, my client is going to enter a plea of not guilty, and I'm going to be waiving arraignment.
All right.
And we're going to be requesting a jury trial.
Okay, got it. Ms. Evans, your attorney is entering a not guilty plea on your behalf. Your case is going to be reset for a jury trial, and you will receive notice. If your parole hold is resolved and you're released on your bond, please be sure that if you change your address, you let the court clerk's office know, not your bonding company, not your best friend, not the United States Postal Service, the clerk of court. That's the first place you stop and let us know that you've changed your address in writing. Understood?
Yes,
So you
ma'am.
won't miss out on your next court date. Thank you.
Thank you, Your Honor.
Ms. McLeod, I'm not going to let you go yet. You have a couple more cases.
I do, Your Honor.
Okay.
I have Mr. Cheese as well.
Okay.
And I also have Mr. Godwin. I have not spoken to Mr. Godwin yet, but I have spoken to Mr. Cheese. I also have Mr. Green, who is going to be on this calendar just so his terms of his previous plea can be clarified.
Okay. So I believe they're all in courtroom 2. So as soon as those individuals are brought forward, we can address them. Meanwhile, while I'm still on position on the add-on calendar, we have LeVar Reed, case 24 CR 5871F, accused of 2 counts of battery from May 15th, 2024. Mr. Reed, you've been advised of your, is that Mr. Reed?
Good morning. Good morning, Your Honor. Teresa Mahfood here with Carson Matthews' office. We represent Mr. Reed.
That is
Position number 18 and 19 in quorum 2.
Mr. As I was saying, you've got 2 counts of battery. Your attorney is Keratin Matthews. We have one of Mr. Matthews' associates on Zoom. Her name is Teresa Mahfood. Do you see her on the screen?
Your Honor, Debbie was trying to let you know that this is position 18 and 19 in courtroom 2.
Oh, no.
Read right here at ACDC.
Okay.
Yeah, but we were trying to do position 18 and 19 before she started.
We could clear the courtroom by doing him next, I believe.
Go ahead, courtroom 2. You guys can go.
All right, 18, 19. Mr. Reed, please hold. Ms. Mahfood, did you need to talk to your client?
Yeah, well, Your Honor, I actually need to talk to the prosecutor. I had tried emailing the last couple of days, but I haven't, and calling, but I haven't heard back. So I just wanted to have a pretrial.
Okay, Mr. Rhodes, is that your case?
Yes, I'll take the plea on position 1819 and she can pre-trial with Ms. McCockey.
All right.
Or vice versa. Ms. McCockey, are you there?
All right, Ms. McCockey, can you put your phone number and or email to Ms. Mahfood in the chat so that she can speak with you? Francois, I'll be right with you after Ms. Mahfood has spoken to the prosecutor, and I'm going on to position 18 and 19.
Not a problem. Thank you.
Arthur Hale, case number 24 CR 687G. and 24 CR 6311G.
Good morning, Your Honor. I'll be handling that.
All right. In both cases, Mr. Hale is accused of criminal trespass. The first position is from February 8th, 2024. The second one's from September 5th, 2024. Mr. Hale, you've been advised of your rights, and your attorney is Mr. Paul Bartel.
Your Honor, I should just address something with one of the cases. I had emailed Ms. Falk about this. I wasn't aware that Mr. Rhodes would be filling in for her. But number 18, we're asking for a null pros on that. That's a DeKalb County case. I used to live in that area. It's right off of DeKalb Avenue going towards Decatur. That's right across from the Candler Park MARTA station. And apparently it got this far without anybody realizing it's not a Fulton case. So Fulton County would not have venue in that. But we are entering a negotiated plea on number 19.
And this is the September 5th incident or the February 8th incident?
The February 8th incident, Your Honor.
Your Honor, I believe I received a email from Deputy Falk as it relates to that. The state has no problem, null pros in position number 18, and we could proceed on position number 19.
All right, position 18 is null pros, position 19. And how would we like to proceed, Mr. Bartel?
It's a negotiated plea, Your Honor.
All right. Mr. Hale, please raise your right hand. Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Correct.
Mr. Rhodes, what's the recommendation?
Yes, Your Honor, as it relates to position number 19, the recommendation is 12 months to serve 30 days, credit for time served for 15 days since September 5th of 2024, and that the balance be suspended. We ask that he stay away from Aldi, located at 3221 Peachtree Street Northeast in Atlanta, Georgia. And that's the recommendation. Thank you, Judge.
Mr. Bartel, do you stipulate to the factual basis, venue, and ID?
We do, Your Honor.
Mr. Hale, have you consumed any medicine or alcohol?
None.
And have you understood what's going on in your case?
Yes.
Are you satisfied with your attorney?
Yes.
Has your attorney explained to you that by pleading guilty, you would have to give up your right to a trial in front of a judge or a jury? You will not go back to a court to have your trial, to confront your accuser, challenge the folks and the testimony and documents brought before you, and have the state, the prosecutor, carry his burden to prove the charge against you beyond a reasonable doubt.
Yes.
So you're willing to give up these rights?
Essentially. Yes. Yes.
How do you plead to one count of criminal trespass from September 5th, 2024?
Yo.
You're sentenced to 12 months to serve 30 days, credit for time served 15 days, balance suspended. You are to stay very far away, 200 yards away from the Aldi store at 3221 Peachtree Street in Northeast Atlanta. If you return to that location, you will be arrested again. And quite frankly, Mr. Hale, this is your 5th arrest in 2024 at Fulton County Jail. Trust me when I say I don't want to see you again this year. Do you understand?
Right. I'll continue to help them.
Okay.
All right. Thank you, Your Honor. Thank you, Mr.
Good morning. I have Mr. Dennis Murphy's client up here in medical. Can we do a breakout?
Yes, appreciate it. I'd like to speak to him.
All right, Ms. Strong, if you could place medical and Mr. Dennis Murphy in a breakout room, please. Jail court iPhone, who do you have?
Wait, I'm sorry, Judge. 1 second, because I'm the person working the Zoom and the court. So give me a second before y'all move on. I just want to make sure I hear it.
I thought you had 8 arms like Mr.
I wish.
Okay.
I'm sorry. Who am I putting in there with Mr. Murphy?
Medical and Dennis Murphy.
Deon Brown. Please.
Right, medical, you'll see a message on your screen. Okay, Mr. Jail court iPhone, who do we have?
We have position number 31, Mr. Long.
And Mr. Rhodes, are you the prosecutor in this matter?
Ms. McCockey, but she might still be pre-trying, so I'll take that one.
All right, and who's defense counsel for Mr. William Long? Ms. Kim?
Yes,
Hi. Oh, okay, thank you. All right, this is State versus William Long, 24 CR 6302Y. Mr. Long is accused of criminal trespass from September 5th, 2024. Mr. Long, you've been advised of your rights, and your attorney is Ms. Kim. How are we proceeding, Ms. Kim?
I believe he was waiver of arraignment, but I want to double check, Your Honor. Give me one second. Yes, not guilty, Your Honor.
Okay. Are you filing a waiver of arraignment?
Yes, Your Honor.
Okay. Mr. Long, your attorney, Ms. Kim, is entering a not guilty plea on your behalf, and your case is going to be further notice for trial. That concludes your
Oh,
case.
no, I plead guilty.
Oh, my goodness. All right, that's
Plead guilty yesterday.
Okay,
This hands heard.
well, you pled guilty yesterday to criminal trespass.
Yes, ma'am.
All right, please hold.
Mr. Long, would you please call me? I'm at the courtroom too. Your Honor, there is a probation that we were discussing yesterday.
So his case was reset from September 6th. No, Mr. Long, I don't know what case you're referring to, but let me just check one more thing. Yes, okay. You have a probation matter and also a criminal trespass. What case will, I don't know, if you want to talk to your attorney, maybe they can clarify with you what case you're discussing. All right? All right. Jail Court iPhone, how can this gentleman communicate with Ms. Kim?
We're gonna, we can't go into a breakout, can we?
Sure.
We can go to breakout.
Ms. Strong, can you place Jail Court iPhone and Courtroom 2 in a breakout? Ms. Kim, no more, not long, please. 2 minutes tops. I don't want extended discussion. I need Courtroom 2, okay?
Thank you, Your Honor.
All right.
Judge, next we have number 11.
All right. And Mr. On position 11, who is it?
Mr. Cheese, and that's for Ms. McLeod.
All right.
It's gonna be a second, Judge, before I can put them into a breakout room.
Okay.
So, for example, you put in for today, and you have to calendar before Thursday, and for adding a good calendar, and what's good time, but you know what Thursday you probably, if you got one problem, you want to like to put in for. Yeah, I'm seeing.
All right, Ms. Mahfood and Ms. Mokeke, going back to position 8 on the add-on calendar. How would we like to proceed with LeVar Reed?
Your Honor, so we're trying to work out a plea on this, a resolution to this, but as I understand from Attorney Makake, Attorney Falk is actually handling this case, and they need some information before they can work out a resolution. So we're gonna the suggestion is to reset it to Tuesday, and hopefully this case will be resolved on Tuesday.
Yes, there is potentially. So we were trying to get this upgraded to a felony. We were just waiting on some medical documents. So once we get those documents, we're going to continue to just work with Mr. Reed's attorney to see if we'll just keep it as a misdemeanor or if we will proceed with trying to get it upgraded to a felony. If not, we can come to an agreement on a plea.
All right.
But we just need some additional time to continue to work that out and get that information.
Ms. Francois, if you could unmute, please. Courtroom 2, you're supposed to be in a breakout with Mr. Long. Courtroom 2. Ms. Strong, please place Ms. Kim in a breakout with the Jail Court iPhone if they're there.
I'm trying, Judge, because of the way the breakout room is with me doing it by myself. I'm trying to see when Mr. Murphy was done so I can reset it. So I'm working on it.
Okay, thanks. Mr. LeVar Reed.
Y'all switch out. This is Mr. Reed.
All right, Mr. Reed, your attorney, Ms. Mahfood, has indicated that we're going to reset the case to Tuesday, September 24th. By that time, hopefully, the prosecution will have a plea offer to communicate with your defense counsel so that they can speak with you to see how you would like to proceed with your case. Do you understand, sir?
Yeah.
All right. Ms. Mahfood, he has been waiting to speak with Keratin Matthews for some time now. I would highly recommend that either you or Mr. Matthews go to the, is it at the ACDC facility? Deputy Director?
Yes, he is, Judge.
And speak with him. I don't know whether he's had any updates from his counsel, but he's extremely patient. This case has been reset multiple times.
I did talk to her already.
Oh, you already spoke to her?
I talked to her.
All right.
This morning, I spoke to him this morning, Your Honor.
All right. In that case, then we'll see him and you on September 24th. Thank you.
Thank you so much, Your Honor. This concludes my business. May I be excused?
Yes, thank you, Ms. Mahfood. Thank you.
Also, Judge, we were trying to get in contact with Ms. McLeod. She left off the Zoom and we still have her case. I'm gonna try to give her a call again.
All right. You got it on speed dial? All right. Mr. Murphy, are you ready to address your case?
I am, Judge. I have spoken to Mr. Brown and will be entering a plea this morning.
All right, this is Dion Brown. Is that position 1 on the add-on calendar? 1 and 2? Mr. Murphy?
Judge.
Dion
Yes,
Brown?
Judge, can you, are we good?
Yeah, I've got 4 cases, 2 bench warrants and 2. But medical was here a second?
Yes. Okay, Judge, we're going to enter a plea to position.
I'm losing my folks. I don't know where they're going.
Judge, I'm not, we're going to enter a plea to position 2. And as part of the agreement, the state would null pros position 1 in the bench warrant.
Okay. Mr. Rhodes, is that correct? Because on the add-on calendar regarding Dion Brown or Dion Central Brown, the state is going to dismiss position 1?
Yes, let me make sure that that is in fact the one that we are dismissing. I do believe that Deputy Falk and Attorney Murphy had an agreement much earlier on, and just want to make sure I got the correct. Yeah, a plea on 22 CR 007-556E, and then we will null pros 23 CR 000194E, which is position number 1. So that is correct, Your Honor.
All right. Mr. Dion, yes,
We're
sir.
going to, Judge, we're going to be, it'll be 66 days credit for 33 and FBIP. That's our understanding. And Your Honor, as a housekeeping matter, I've spoken to Mr. Brown and he's authorized me to sign an initial on the plea forms, and we've gone over the plea forms.
All right. If that's the case, then please make sure you send the plea forms to Miss Casey Strong today, okay?
Yes, Judge, I'll have it shortly thereafter. I'm here at the courthouse.
Okay. This is State versus Dion Stantrell Brown, case number 22 CR 007556E. Mr. Brown is accused of battery family violence from November 3rd, 2022. Mr. Brown, you have a right to remain silent. Anything you say in open court about the facts of your case, your statements can and will be used against you. You have a right to an attorney, and representing you is Mr. Dennis Murphy. With respect to this case, we're going to take a plea. Please raise your right hand. Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
I do.
Mr. Rhodes, how is it going to be 12 months to serve 66 days, credit for time served 35 days with an FBIP? Anything else?
Yes, Your Honor, that is correct. The only other conditions are no further contact with Mr. Kevin Fountain and to stay away from 9995 Old Dogwood Road, Boswell. and we ask that he have no firearms. That is in case 22 CR 007-556E.
Yes. the one, yes.
Number 1 will be null pros along with positions number 3 and 4.
Okay. Mr. Murphy, do you stipulate the factual basis, venue, and ID? Oh, please tell me I've not lost Mr. Murphy. Ms. Strong, did Mr. Murphy drop off the Zoom?
It looks like it. It doesn't seem like he had the best service. Yeah, he's not on at all anymore.
All right, let's just put a hold on this one until the defendant's attorney comes back on Zoom. I have Miss McLeod here.
I am here, Your Honor.
All right. Francois? Oh, Mr. Murphy, we're back. Okay, Mr. Murphy, we were still addressing Mr. Brown. Do you stipulate to the factual basis, venue, and ID?
We do so, Judge, and I wanted to add that my client wanted to take this plea pursuant to the First Offender Act, and he's aware of the benefits and cons of that, and he wants to take it pursuant to First Offender.
Has he been convicted of battery in the past?
I do not believe so, Judge.
Mr. Rhodes?
The state has no objection to
All right.
First Offender.
Mr. Brown, have you consumed any medicine or alcohol?
No, ma'am.
And have you understood what's going on in your case?
Yes, ma'am.
Are you satisfied with your legal services?
Yes, ma'am.
And is anyone forcing you or inducing you to take this plea today?
No, ma'am.
If you decide to plead guilty to this charge, you would have to give up your constitutional right to a trial. You will not be able to confront your accuser, challenge the evidence that will be brought against you, present your own defenses and arguments if you choose to do so, and have the state carry its burden to prove the charges against you beyond a reasonable doubt. Are you prepared to give up these rights?
Yes, ma'am.
How do you plead to one count of battery, family violence from November 3rd, 2022?
Guilty.
And this would be a guilty plea under the First Offender Act, which means that if you complete all the terms of your sentence in a satisfactory manner, this conviction cannot be held against you. Do you understand?
Yes, ma'am.
All right. So with regards to your sentence, it's going to be 12 months. Served 66 days, credit for time served 35 days, balance probated. You will report, does he have any other holds, Mr. Murphy?
Not that I'm aware of, Judge.
All right. If you don't have any other holds, Mr. Brown, you will report to probation on Monday, September 23rd, before 3 p.m. When on probation, you will enroll and complete a domestic violence intervention program. This is a series of 24 weekly classes, and you must enroll in those classes within 45 days of being released. And you will attend every week with no absences. You will also have no contact with Kevin Fountain, and you must stay away from 9995 Old Dogwood Road in Roswell, Georgia. And at no time are you allowed to own or possess or have a firearm anywhere near you. Do you understand, sir?
Yes, ma'am.
That completes your sentence. Position 123 CR 194E is null pros, along with the 2 bench warrants under positions 3 and 4. Thank you, Mr. Brown.
Thank you, Judge.
Thank you, Ms.
Thank you.
All right.
Judge, as a housekeeping matter, Judge, I do have his probation information sheet. I will submit it to the court as well.
Truly appreciate it. Thank you, sir.
Thank you, Judge. Good day.
Deputy Francois, who do you have?
This is going to be number 11, Mr. Cheese, and I do see Ms. McLeod is signed back on. Okay. Thank you.
Ms. McLeod, this is Quintavious Cheese, 24 CR 6280A, accused of battery, family violence, and cruelty in the 3rd degree. Mr. Cheese has been advised of his rights, and how are we proceeding with your client's case? Ms. McLeod?
Yes, Your Honor, I'm here.
No problem. I was just wondering, how would you like to proceed with Mr. Cheese?
I don't know which one of my clients it is.
Mr. Cheese, number 11.
Quintavious,
Mr. Cheese.
yes.
Yes, Your Honor. This is going to be a not guilty plea, and I will be filing a waiver of arraignment. Mr. Cheese would like to have a trial.
The attorney will come out and talk with you. I told you he was out here, okay?
Okay, thank you
No problem.
All right. Mr. Cheese, your attorney has indicated that she is filing a waiver of arraignment and a not. Ms. McLeod, if you could mute your screen for a minute, please. Thank you.
Yes, Your Honor.
As I was saying, your attorney is entering a not guilty plea on your behalf, and your case is going to be further noticed for trial. That concludes your matter. Thank you. Anything else at ACDC, Francois?
That's it. We're completed here at ACDC. Thank you, Judge.
All right, Ms. Kim, we are addressing your client, William Long. Or was it? Yeah, I believe it was William Long.
Your Honor, even though I advised against, he would like to plead guilty, and he will go as a pro se, Your Honor. And for the record, I strongly advise against it. Thank you.
Has Mr. Long been provided with the paperwork to enter the plea?
I want to represent myself pro se, ma'am.
Well, I know you're going to represent yourself, but you still need to review the paperwork, read the rights, and fill them out so that they can be transmitted to the clerk's office. So, Ms. Mokeke, do you have the plea paperwork for William Long?
I do not have it currently with me, but I can get it.
Okay. Officer at Jail Court iPhone, how would Mr. Yes, Mr. Long?
Yes, ma'am. Ms. Loud, I don't mean no disrespect to the courtroom today, but Mr. Lamar Rhodes, I think you are a pretrial officer. I just served 11 served 6 for the probation they said I'm on. I served 11 years, served 6 to spin the balance. I did 6.5 years in prison, but they not looking into that. My lawyer, that's why I say I want to represent myself pro se, because they're not looking into that. I just served 6 years, sir. I just came home, sir. All I'm trying to do is get home to my family. I just served 6 years in prison. I went to Hancock, I went to Hayes, I went to Reedville State Prison. I just came home in 2022. From 2016 to 2022, sir.
Sir, let me apologize. I'm not the pretrial officer. I am the prosecutor.
Oh, sorry, sir.
So I'm sorry. I think I was on pretrial with Attorney Mahfood. This is basically a time served plea. The balance is suspended. He just needs to stay away from that Chevron.
Well, I'm not quite sure what he was talking about in terms of his probation or his parole. So, Mr. Long, first of all, you have a right to remain silent. Anything you say about your case or cases, your statements can and will be used against you. You have a right to an attorney. If you cannot afford one, one would be appointed to represent you. If you choose to waive your right to counsel and represent yourself, then you are responsible for understanding how the law applies to the facts of your case or cases. And if you choose to speak on your behalf, you will be subject to cross-examination, and anything that you say can and will be used against you. So, on this information, would you like to continue to be represented by the Public Defender's Office, who can share the wealth of their legal experience and knowledge with you? Because I don't know how much legal knowledge you have.
I don't, ma'am, I'm trying to figure out the case that we're speaking about today. What is this about?
Mr. Long, would you like to continue to be represented by?
No, ma'am. No, ma'am.
All right. If you decide to waive your right to counsel, then you are representing yourself and you are responsible for understanding how the law applies to the facts of your case.
Yes, ma'am.
Are you willing to waive your right to counsel?
Okay. That's. Yes, ma'am, I'm willing to.
You are charged with criminal trespass.
Yes, ma'am.
The incident date is September 5th, 2024. And the allegation is that you trespassed at a location at 1337 Virginia Avenue in East Point, Georgia, Fulton County, a Chevron gas station. That is what you are here for. And no
I'm
other.
guilty, ma'am. You said, it's time served, if I plead guilty, right? Yes, ma'am.
The recommendation from the state is to serve 12 months, just 12 months to serve 30 days, credit for time served 15 days, balance suspended, and to stay away from the location in question.
Yes, ma'am. Yes, ma'am.
All right, Ms. Kim, you can withdraw from the case. And Deputy, how shall the prosecutor email the plea paperwork so that Mr. Long can review it and send it back to the clerk's office?
If it's, I mean, I guess if it's back to the courtroom, I can bring it up to him.
Will he be able to come down to courtroom too?
Yeah, I can do that too. I can bring him down there too.
Okay, that's the only way I can do it. Yes, Mr. Long?
Ma'am, thank you so much. And I was wondering, do I have any holds on me, ma'am?
I'll find out when you review the plea paperwork.
Yes, ma'am. Thank you, ma'am.
All right, yeah, so I can bring him down there on courtroom too.
Sounds like a plan.
So should I send that plea paperwork to?
Courtroom 2, at courtroom 2, who would be available to take a copy of the paperwork?
Officer Norris and Officer Saint Serene.
All right, I think Officer Norris, could you put your email or whichever email you like to have us send it to
I'll
you?
send that to Ms. Kokake. I'll send it to her. Thank you.
Okay, thank you.
Deputy at jail court iPhone, he's ready to come down to courtroom 2. The paperwork will be there for him to review.
Okay.
Shortly.
Okay.
All right, thank you.
Yeah.
All
Ms. McKay.
Okay, courtroom 2, do we have anyone to address there? We have 51 cases plus add-ons, so there must be something for me to address today. No?
I'm sorry, Judge, can I address Ms. McLeod? Ms. McLeod, you only have one more case, that we're waiting on, Goodwin, correct?
I actually also have Mr. Green, but Mr. Green, he's just on to have the terms of the plea that he took in July clarified because the jail is not showing the appropriate time. So he was put on today so we could get that clarified so that the jail could be showing the time. He's supposed to be getting out at the end of September, but the jail is still showing him getting out at the end of December.
What's the first name, Ms. McLeod?
Quantavious Green. I believe he's on the add-on.
I don't see him on today's add-on, Ms. McLeod. Give me a second. What day was he previously on?
He was on in July, at the 30th of July, but he was placed on for today. He's supposed to be on he's actually on the regular calendar, I think.
Miss McLeod, we have Hardrick Godwin.
Yes, Mr. Godwin is my client, and I haven't spoken with him yet, Your Honor. I do need to speak with him.
Okay, that's position 6 on the add-on. And then if you can put these case numbers for Mr. Green in the chat to Ms. Strong, we'll be able to look it up.
Yes, Your Honor, I will do that.
Ms. Strong, before you do anything, there is a Marquis Ferguson on the Zoom. He needs to go back into his apartment and put on some clothes and not smoke. Take him out of the Zoom, off Zoom, completely out of Zoom. Remove him from Zoom, please. Thank you. All right. Okay, so we are waiting on, by any chance, are any of my bench warrant cases available? I have, That's not scheduled till 11 a.m. for today, but I have a Paul Dwayne Childs and a Vincent Jamal Lindsay Jr. No luck either. Okay. All right. We are waiting on the plea paperwork. We're waiting on courtroom. Okay, medical. Yes, medical. Who do we have, please?
This is Mr. Green, Miss McLeod's client.
Okay. Miss, what's his full name, Deputy?
Tell me her name.
Quantavious,
Quantavious Green.
What's his case number? Because I still don't see him on the calendar unless I'm missing something.
I just need a case.
23 CR 004422G.
Thank you.
One more time, I'm sorry.
23 CR 004422G, as in girl.
G as in gold. Okay. There we go. And he's scheduled for September 24th on our state all-purpose calendar today. He already entered a plea. He just needs the address and need to address the correct amount. So Mr. Quintavious Green, let's see.
Okay, I'm gonna return because since this has the 24th on there, I don't have any information on him.
Yeah.
So I'm gonna,
Scheduled for the 24th, which is next Tuesday, Miss McLeod. But if you're just addressing a error in the disposition sheet, I can go ahead and take that right now.
Thank you, Your Honor.
Mr. Quintavious Green is 23 CR 004422G. Looks like he took a plea on July 30th, 2024 before Judge Morrow. And looks like he was given credit for 119 days. Okay.
That is correct, Your Honor.
All right. And sorry, Mr. Green, you're at the medical unit. Please remember that you have a right to remain silent. Anything you say in open court, your statements can and will be used against you. You have a right to an attorney, and Ms. McLeod is your counsel. Ms. McLeod, can you tell me what's the discrepancy there?
Yes, Your Honor. The discrepancy, when it had been calculated, given the time that they wanted him to spend with 2-for-1 in Fulton County, he should have been coming out on the 30th of September. But for some reason, the jail is showing him as coming out on the 31st of December, which is 3 months longer than the time that had been calculated at the time when he took the plea.
He's, so this was the plea on which charges?
He had 3 cases, Your Honor, and when he actually took the plea in July on 2 different occasions. He took the plea. The last one that he took was on the 30th of July, and that was to run concurrent with the other one. So when he took the initial plea, and I do have the paperwork, which I can send to the court, he had credit for 119 days. And when it was calculated, he's been in jail for almost 2 months since that time. And the calculation we had done at the time indicated that he would get out on the 30th of September. But for some reason, the jail screen continues to show that he won't be released until the end of December. So we're just trying for the state to clarify that. I sent several emails. I have been back and forth with the state just trying to get this resolved. And that is the reason why it was put back on the calendar, Your Honor.
All right. Since I wasn't the judge who took the plea, I'm assuming, because right now, when he was booked in on July 3rd, 2024, he had a total of 79 days in custody. When he was booked in on February 29th, 2024, he had 4 days in custody. And then when he was booked in on March 26, 2023, he had 114 days in custody. The only thing I can assume is that they gave him custody from the March 26, 2023 booking, and the February 29th, 2024 booking, which adds up to 118 days or 119 days, if you include the day he took the plea. And then the 79 days, looks like he's got a felony charge. So
Was he being held on the felony charge, Your Honor?
he's got a $5,000 surety bond on the felony charges. I've got receipt, possession, or transport of firearm by convicted felon, the theft by receiving stolen property, and a battery charge, and a reckless conduct.
No. And sometimes that will happen in my experience, where if they are arrested on a new felony charge and they're not necessarily in on the misdemeanor, the jail won't give them credit for that because they're technically not in for that.
And then,
So-
well, I'm just letting you know what the jailing screens show. And then he's on probation for a offense from March 22nd, 2020. And he's on probation for 2 counts of simple battery from July 1st, 2024. And also one more battery count from May 12th, 2024. So it's a lot going on, Ms. McLeod, and I honestly don't have a clear answer for you in terms of why the jail is giving you a December 30th release unless he's got a probation ruling.
That is, my understanding is that he has nothing else, Your Honor, and that is the reason why we don't understand why it has not changed in the system, because all of the misdemeanor cases that he has in Fulton County have been resolved.
And now he's got this felony case and his probation hold. So the misdemeanor cases are most likely not holding him. But if you'd like to come back on September 24th and address that with Judge Morrow, because he'll be the one doing the SAP. Since he took the plea, he may have more information about it than I can provide. I can only read you the jailing screen since I didn't take the plea. So,
And Your Honor, if I can, it looks like from the notes I'm reading on 7/25/24, the very first case, which was 23 CR 004-422G, which was a battery, what the plea was 12 months to serve, and he did receive credit for time served back then for 114 days. But if it was 12 months to serve and he only had 114, that would have left approximately about 250 days, which is almost half a year. So the December date, based on that, might very well be right, because it was 12 months to serve in 114 days on July 7th, with 250, presumably with 250 more days to go or so. It does seem like that's a lengthy amount of time.
I couldn't answer the question clearly for you, Ms. McLeod. I can only tell you that what I'm looking at is a open felony case, probation matters, and then the disposition.
Your Honor, he can post bond on his felony case. He has a bond. The issue, from what I understand, is the way the time has been calculated. At the time when Mr. Green took his plea, the time was calculated, and it was determined at that time that if he was going to get 2 for 1, he would be able to get out on these charges, to which he took the plea on the 30th of September. Based on the credit that he had and the amount of time that he had already served.
326, 12 months to serve. It doesn't say what, but it says credit for 119 days. So
it was 12 months to serve, Your Honor.
maybe another plea sheet would have the information. Because all it says is credit for time served, 119 days.
Yes, Your Honor. So if he got credit for 119 days at that time, if he's gonna receive 2 for 1, it will still come out to the end of September, where the jail is showing
What about the guilty plea? What about the probation matter? Does that hold him?
Is probation matter, Your Honor?
Yeah,
I am not aware that he has a probation matter in Fulton County.
maybe it would be the plea. I don't know, honestly. I'm just looking at it. He appears to have probations from the 1 count of battery and 2 counts of simple battery. Another count, were those the cases that he was placed on probation? And
Yeah, no, Your Honor.
okay. Oh my. First out in jail warrant. All right. Miss Thomas. With probation?
Mr. Green, what do you want to say?
Yes, I wanted to say, I was trying to say, like, all this are correct. Like, what about August the 22nd when I just took the plea, that non-negotiable plea for the 12-month ran concurrent with the probation? And I'm supposed to get out, I'm supposed to have 62 days to serve, supposed to be up on September 27th. That's in the system. I just went to court August 22nd and she took the negotiable plea, ran it concurrent with the probation that I just took July 30th. For the simple batteries and the 2 batteries all ran together concurrent. They said no more jail time, supposed to be time served September 27th. My felony case, that's different. That ain't got nothing to do with none of this. I got a bond for that.
I'm not sure, but he's got 1 time served date for December 28, 2024, and he's got another time served date for September 27, 2024. So, Ms. McLeod, you will have to research his felony case, his probation cases, and his misdemeanor cases to see which sentences run all the way through December 28 and which one runs all the way through September 27. He may have already, his obligations for the plea that he took with you may be concluded on September 27. But
that was my understanding, Your Honor, that they should be concluded on that day. What he's saying is that he has a bond for the felony matter, so he can get out once he finishes the time that he has to serve on my cases that he pled to. And that way he would be able to get out on September 27th by posting bond on his felony case.
Yeah, and that's what it says. He has a time served date of September 27, 2024, according to your disposition. I don't know what is the time served date to December 28th referencing. And that's where you have to do the research on his other open cases. All right. But you still have the date with Judge Morrow on September 24th. You can look at it at that time.
Yes, Your Honor, I will do that. Thank you.
All right. Thank you, Mr. Green.
Your Honor.
Yes, is anyone ready while we've had that long discussion with Mr. Green?
Your Honor, this is Deputy Rhodes. I was just, you probably already know this. I just saw it, but there's in jailing, there's a jail time log that tells how many days he got credit for which charges. And it does look like the felony charges, like I'm showing like 192 days for them, but the misdemeanors, they're way less. It's like they gave them credit for 81, 28, 28, 28. So it could be the way that they calculated it. But you probably were looking at that screen, so I just stumbled upon it.
Your Honor.
Right, you ready with anyone?
Mr. Long, the pro se defendant, is down here. We aided him in his completing his paperwork, and I can just fax it over, I guess, if that's what Ms. Strong would like us to do I mean, email it over when I email my paperwork. So
Fine. If he wants to hang on to the paperwork while we go through the plea, then you can fax it later so that he has something to follow by. But we can take his plea right now if he's ready. If he's gone through everything and signed the documents. And also, does he have the waiver of counsel document as well, Ms. Mukeki?
There, on the plea form, there is, he signed that part where it says he's knowingly waiving his right to counsel. I'm sorry, right, that's right to jury trial. We don't have the right to counsel. So that would have to come from the state.
There is, on that last page, there is a defendant's waiver of right to counsel.
Last page of what?
So there are 3 pages to the plea
We don't-
paperwork.
We don't have a third page plea paperwork because we don't keep a waiver of right to counsel because we're representing somebody. So that's only the state only has that third page.
Oh, I did send the plea paperwork to Deputy Norris.
Oh, I wasn't aware. Deputy Norris is not in the courtroom either, so. Do you have?
Yeah.
Do you have access to one we can print out? A waiver of
Okay.
counsel? Yeah, I mean, there's no reason for us to have one.
And I sent it, PD Kim was also included in that email.
All right, we'll see if we can print it out. I mean, that's also an iffy situation here at the jail. We'll give it a best shot.
Yeah. Sure.
All right, while we're waiting for Mr. Long to show up in the chair with this paperwork completed, it's Mr. Paul Childs on Zoom. Paul Childs? No?
The green.
Mr. Lindsay? Mr. Long, do you have 3 pages that you had to review? How many pages do you have?
Judge, he only has the plea paperwork. I mean, he understands that he does not have.
Look at the back, maybe it might be at the back. I don't know. Sometimes they print front and back.
This is came out of my, I do not do that.
Oh.
This is one of them.
You know, go get it.
Let me see if I can.
All right, we're going to see if the other one is printed,
Okay, no problem.
but I mean. We wanted to go over the rest of it with him. I don't know how you.
All right, medical, who do we, courtroom 2, please mute for the, well, don't mute. Medical, who do we have?
Number 8, Sean Brown.
Thank you. This is Sean Brown at the medical unit, case 24 CR 6332C, accused of simple battery, family violence. Mr. Brown, you have a right to remain silent. Anything you say in open court, your statements can and will be used against you. You have a right to an attorney if you cannot afford one. Mr. Tom White will be representing you. Mr. White, is Sean Brown your client?
He is, Your Honor.
All right, and how are we proceeding?
I believe it's a plea. Yes, it's a negotiated plea, Judge.
All right, Mr. Brown, if you please raise your right hand. Swear and affirm the testimony you provide will be the truth to the best of your knowledge.
Yes, ma'am.
Miss Mukeki or Mr. Rhodes?
Sorry, Judge, what position is this?
8 on the regular calendar, Sean Brown.
Your Honor, as it relates to Mr. Brown, state's recommendation is 12 months to serve 30 days. Credit for time served 15 days since September 5th, 2024. Balance be on probation. He completes the 24-week family violence intervention program. He completes 40 hours of community service. No further contact with Nicole Harris, and stay away from 311 Scott Street.
Mr. White, do you stipulate to the factual basis, venue, and ID, and does your client accept these terms?
Yes, Your Honor, we do stipulate. We would ask for a waiver of fees for as long as the court can grant, and Ask for a non-reporting status once he's completed everything.
And the reason for the waiver?
I'm sorry?
Is he unemployed or what's the reason for the waiver?
He is not employed at this time, Judge.
I'll waive the probation fees for the months of, through September, October, and November. He will start paying probation fees from December 1st, 2024 onwards. Mr. Brown, have you consumed any medicine or alcohol?
No, ma'am.
And
I've
have-
consumed medicine. High
Medicine,
blood pressure. Yes, ma'am. High blood pressure medicine.
I see. And after consuming the medication, are you still able to understand your attorney and what's going on in your case?
Yes, ma'am.
Are you satisfied with your legal services?
Yes, ma'am.
And are you entering this plea freely, willingly, and knowingly?
Yes.
If you decide to plead guilty to this one count of simple battery family violence, you would have to give up your constitutional right to a trial in front of a judge or a jury. You will not get the opportunity to go back to a court of law, to confront your accuser, challenge the evidence brought before you, have the assistance of counsel to present your arguments and defenses, and have the state carry its burden to prove the charge against you beyond a reasonable doubt. Are you prepared to give up these rights?
Yes, ma'am.
Repeat.
Yes, ma'am.
How do you plead to one count of simple battery family violence?
Guilty.
Your sentence is 12 months to serve 30 days, credit for time served 15 days. It looks like you've got a probation hold. Has that matter been resolved, Mr. White?
It has not, Judge.
All right. So as soon as you've resolved your probation hold, you'll be released and you'll have to report to the Fulton County Probation Office on the first available weekday, which will be Monday, Tuesday, or Thursday before 3 p.m. When you report to probation, you will complete the following conditions. You have to complete a 24-week domestic violence intervention program, and you must enroll in that program within 45 days of being released. You are to complete 40 hours of voluntary community service, and you can do that at any nonprofit agency that's not a church and not a school. And you must complete a minimum of 5 hours per month and a minimum of 5 hours every month thereafter. At all times while you're on probation, you are to have no contact with Nicole Harris, and you cannot return to 311 Scott Street in Atlanta, Georgia. You have to stay 200 yards away from that location. As I said, I will waive probation fees for the first 3 months. So whenever you begin probation, they will calculate the first 3 months of waiver. And then after that, you'll need to start paying probation fees.
Yes, ma'am.
All right. That concludes. Thank you.
Judge, we did get, we were able to print out the waiver of right to counsel, so.
While we're waiting on that, Mr. White, who is that jail court iPhone?
We have position 6 and 7 on the add-on calendar, the Godwin.
Ms. McLeod, that's your client, Mr. Godwin. Is that the individual you need to speak? Whom you need to speak? Ms. Maureen McLeod? All right, jail court iPhone, please hold. I'm still waiting for his attorney to appear on Zoom, okay?
Okay.
All right, Mr. William Long. We're going to resume if Mr. White, we're going to resume with his case 24 CR 6302Y. The Public Defender's Office has withdrawn from this case, and Mr. Long has waived his right to counsel and is choosing to proceed pro se. Mr. Long, please raise your right hand for the purposes of your case 24 CR 63021. Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yes, ma'am.
Thank you. Ms. Mukherjee, what's the recommendation?
The state's recommendation for the criminal trespass is 12 months to serve 30 days, credit for time served 15 days, balance suspended, and a stay away from the Chevron gas station located at 1337 Virginia Avenue in East Point, Georgia.
Mr. Long, this is the recommended sentence from the prosecutor. Just give me a moment, please. Ms. Strong, can you place jail court iPhone and Ms. Maureen McLeod in a breakout? Ms. McLeod, you would need to start your video in order for Ms. Strong to go ahead and, all right, thank you. Okay. So, Ms. Strong, it will be jail court iPhone and Maureen McLeod in a breakout, please. Thank you. Mr. Long, this is the recommended sentence if you decide to plead guilty to criminal trespass.
Yes, ma'am.
Well, I still have to ask you a bunch of questions by law, so you need to pay attention. First of all, do you agree that the prosecution has the correct defendant, that is you, William Long, for this case?
Yes, ma'am.
Do you agree that this criminal trespass offense from September 5th, 2024 occurred in Fulton County, Georgia?
Yes, ma'am.
And do you agree that the factual basis supporting this charge is true and correct?
Yes, ma'am.
Have you consumed any medicine or alcohol recently?
No, ma'am.
Have you reviewed the documents and understood the nature of the documents that you've reviewed?
Yes, ma'am.
Are your responses to those questions and those documents true and accurate?
Yes, ma'am.
And you have voluntarily waived your right to counsel, correct?
Yes, ma'am.
And in reading those documents, do you agree that if you decide to accept this plea offer, you would have to give up your constitutional right to a trial in front of a judge or a jury? You will not get the opportunity to go back to court, to confront your accuser, challenge the evidence that we brought against you, have the assistance of counsel to present your defenses, arguments, and mitigating factors, and also to have the state carry its burden to prove the charge against you beyond a reasonable doubt. Are you prepared to give up these rights?
Yes, ma'am.
How do you plead to one count of criminal trespass?
Guilty, ma'am.
Your sentence is going to be 12 months to serve 30 days, credit for time served 15 days. The remainder of the sentence is going to be suspended. You are to stay 200 yards away from the Chevron gas station at 1337 Virginia Avenue in East Point, Georgia. If you're seen anywhere within 200 yards at its parking lot, sidewalks, or in that building, you will be arrested again and brought back to jail.
Yes, ma'am.
Thank you. That completes your sentence.
Yes, ma'am.
All right, Deputy Norris or Mr. White or Ms. Kim, if I can impose on you to send the plea paperwork back to Ms. Strong, that would be very helpful. Thank you. All right, so Ms. Strong, who do we have in a breakout right now?
Ms. McLeod in jail court iPhone.
Okay. All right, let's check on the status of
Yeah, he doesn't get it back. It's gotta go to the judge.
all right, medical, we have someone there. Who is it, please?
Position number 20, Mr. Harris.
Thank you. This is State versus Taibon, Taibon Harris, 24 CR 6312J. Mr. Harris has been accused of willful obstruction of a law enforcement officer and simple battery against an officer from September 4th, 2024. Mr. Harris, you've been advised you have a right to remain silent about the facts of your case. Anything that you choose to say during the course of this virtual proceeding, your statements can and will be used against you. You have a right to an attorney, and representing you is Mr. Tom White. Mr. White, will this be a plea?
It will, Judge.
Mr. Harris, please raise your right hand. You solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge.
Yes.
Thank you. Mr. Rhodes, what's the recommendation for Mr. Harris?
Yes, Your Honor, as it relates to Mr. Harris, count one, the willful obstruction, the state is recommending a time served 30 days, credit for time served 15 days since September 4th of 2024. On count two, which is the simple battery against police, the state's recommendation is 12 months to serve 30 days, credit for time served 15 days, the balance to be probated. And as it relates to treatment, we'd leave it up to his attorney whether or not he needs MHET or BHET. Also, that he stay away from Texaco, located at 315 North Central Avenue in Hapeville. And that's the state recommendation. Thank you, Judge.
All right. Mr. White, do you stipulate to the factual basis, venue, and ID, and does your client accept these terms?
We do, and he does, Judge, and we selected the behavioral health evaluation and treatment. We would ask that you waive a couple months fees. He does not have a job right now. We'd also ask that he go non-reporting once he completes those requirements.
Any objection to non-reporting? Looks like other than a probation hold, it's been relatively light, unless you have something different, Mr. Rhodes.
No objection, Your
Right. Latanya Lowe, who wants to speak? Is Miss Lowe, are you involved in this case? Okay. All right. Mr. Harris, have you consumed any medicine?
No. No medicine.
Latanya Lowe, please mute. Yes. Okay. Ms. Harris, I'm so sorry. Have you consumed any medicine or alcohol? Did you say no?
No.
All right. And have you understood what's going on in your case?
Yes.
Are you satisfied with your legal services?
Yes.
Is anyone forcing you or inducing you to take this plea offer today?
No.
If you decide to accept the plea offer and plead guilty to these charges, you would have to give up your constitutional right to a trial. You will not be able to go back to court to confront your accuser, have the chance to challenge the evidence brought against you, present your own defenses and arguments, and also have the state carry its burden to prove the charges against you beyond a reasonable doubt. Are you prepared to give up those rights?
Yes.
How do you plead to one count of willful obstruction of an officer and simple battery against a police officer?
Guilty.
On the willful obstruction is going to be a time served of 30 days, credit for time served 15 days, and that's completed. So your obligation for the willful obstruction is done. For the simple battery, your sentence is 12 months to serve 30 days, credit for time served 15 days, balance probated. You don't have any other hold, so you will report to probation on Monday, September 23rd before 3 p.m. The probation office is located at 132 Mitchell Street in downtown Atlanta. While you're on probation, you will undergo a BH evaluation and submit yourself to any treatment as required. You're also to stay away from the Texaco gas station, 200 yards away from that gas station, and that's located at 315 North Central Avenue in Hapeville, Georgia. You return to that location, you will be arrested again. You understand, sir?
You said that the last part of it, the Hapeville location, that was the Texaco?
Yeah, you cannot return to that location. You have to stay 200 yards away from that location.
Okay.
If you return there, you'll be arrested again.
Okay.
All right? For your behavioral health evaluation, your BHET, you must undertake that within 45 days of being released. Do you understand? So you can go to any healthcare provider, but you need to undergo that. And your probation fees will be waived up to and including November 30th, 2024. On December 1st, if you haven't done the BH evaluation yet, then you will start paying probation fees from December 1st onwards.
Okay.
Thank you.
Thank you, Your Honor.
All right, Ms. McLeod, are we ready to proceed with Mr. Godwin?
We are, Your Honor. It's going to be a negotiated plea.
This is State versus Roderick Hassan Godwin, 22 CR 28482, accused of simple battery family violence from September 18th, 2021. Mr. Godwin also has a bench warrant, 24 FTA 1304. Mr. Godwin, you have a right to remain silent. Anything you say in court, your statements can and will be used against you in the treatment of your case. You have a right to an attorney. If you cannot afford one, Ms. McLeod will be representing you as your appointed counsel. Okay, Mr. Rhodes, what's the recommendation for Mr. Godwin?
Yes, Your Honor. As it relates to Mr. Godwin, on the simple battery family violence, the state is recommending 12 months to serve 129 days. They receive credit for, looks like he's received credit.
Okay, I'm sorry, Mr. Rhodes, we're getting a lot of background noise. Can you hear me all right? Mr. Rhodes, can you hear me?
Yes, I can hear you.
All right, and I'm not certain where the background noise is coming from. Okay, could you please allocate the plea again, the sentence again? 12 months to serve 129 days?
Yes, and the credit for the time that he has served already. The balance,
9 days?
it looks like it's 129 days that he served. The balance to be on probation. We ask that he have no further violent contact with Latandia Lowe, and that he undergoes a 24-week family violence intervention program. And Your Honor, as it relates to position number 7, which is the FTA, we will be sending over a null pros on that case.
I have 2 things to add. First of all, Latanya Lowe, if you want to address this case, please feel free to start your video and unmute your screen if you want to address this case involving Mr. Godwin. All right. The second thing is, Mr. Rhodes, I'm looking at the notes that was submitted by prosecutor Ms. Falk. It says to serve 129 days, credit for time served 129 days, day for day. So it looks like the prosecution is not doing a 2-for-1.
Your Honor, he already spent the 129 days.
Well, that's what I'm bringing it up. I don't want any discrepancies down the road. I'm looking at the notes from Ms. Falk, and I'm assuming Ms. Falk wrote those notes.
That is correct, Your Honor, she did.
So it says to serve 129 days, credit for time served 129 days. Is that your understanding, Ms. McLeod?
It is my understanding, Your Honor.
So it's day for day. He's not getting a 2-for-1 deal.
That is my understanding, Your Honor, that he's already spent the 129 days.
Right. But Ms. McLeod.
Yes, Your Honor.
He's been given credit for 129 days. So typically we give a 2-for-1, right?
Yes, Your Honor, typically. But in this case, he's already served 129.
So
and if I can clarify, we don't give 129 days, the jail gives 100. We don't give 2-for-1, the jail gives 2-for-1.
Understood, but your Ms. Falk is expressly asking for day for day.
I believe that Ms. Falk should have asked for whatever 129 times 2 is. My math is off. To make sure that he serves day for day. Because if the jail is going to give him 2-for-1, they're going to give him 2-for-1. But he will get out under this, because if he served 129 days and we're only asking for 129 days and they get 2-for-1, they're going to let him out anyway.
Right, and he accepted this plea offer based on the fact that he had already done 129 days, and the understanding that he would be released today, barring any possible holds.
So, Ms. McLeod, the way I'm going to read his sentence is 12 months to serve 129 days, credit for time served 129 days, and that would give him adequate time. It's a slim amount of time, but to do his FVIP within 24 weeks. Are we all on the same page?
Yes,
Your
Your
Honor.
Honor, we are. And could I ask the court if the court would waive some of his probation fees, given how long he's been in jail, to give him a chance to get back on his feet?
I will waive his probation fees through the end of the year, but he starts paying from January 1st, 2025.
Thank you.
All right. So, Ms. McLeod, since I've cleared that up, do you stipulate to the factual basis, venue, and ID?
I do, Your Honor.
All right. Mr. Godwin, jail court, please unmute. All right. Ms. LaTanya Lowe, did you want to address this case?
No, ma'am. Thank you so much.
Okay, please mute yourself. Thank you. Mr. Godwin, have you consumed any, oh, sorry, I didn't place you under oath. Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yes, ma'am.
Have you consumed any medicine or alcohol?
Negative.
And are you satisfied with your attorney?
Yes, ma'am.
And you understand that once you are released, you will need to do a 24-week domestic violence program.
Understood.
You have a limited time on probation, so I'm going to put you on a strict schedule, and you're going to have to comply with that schedule.
Yes, ma'am.
All right? Are you entering this plea freely, willingly, and knowingly?
Yes, I am, Your Honor.
And are you satisfied with your attorney services?
Yes, ma'am. I have one question if it's not a problem.
Go ahead.
I'm trying to check out the stipulation. Was it no violent contact?
That is correct. No further violent
Yes,
contact.
ma'am. Yes, ma'am. That's all I was asking.
Okay. Going back to your plea, has it been explained to you that if you plead guilty to this charge, you would have to give up your constitutional right to a trial? You will not get a chance to go back to court to have a trial in this matter, to confront your accuser, challenge the evidence that we brought before you, have your attorney assist you so you can present your defenses and arguments, and have the state carry its burden to prove the charge against you beyond a reasonable doubt. Are you prepared to give up these rights?
Yes, ma'am.
How do you plead to one count of simple battery family violence?
Guilty, Your Honor.
Your sentence is 12 months to serve 129 days, credit for time served 129 days. I don't believe you have any holds, so you should be released within 24 hours, and you must report to probation on Monday, September 23rd, before 3 p.m. Today is Thursday. You'll be released most likely by tomorrow morning. Make sure after the weekend you are in the probation office on Monday before 3 p.m.
Excuse me, Judge. I'm looking at his booking screen and I don't know if the fugitive hold is off.
Oh my goodness, don't tell me that hold is still there.
Yes, ma'am.
Oh. I saw this.
Yeah, they still have it posted as a hold,
Yeah.
for Robertson County, wherever that location is at. I don't know what state.
Miss McLeod, your client is not getting out.
It appears that way, Your Honor, if there is a hold. I was not aware that he had a hold.
Mr. Godwin, did you tell your attorney that you had a fugitive hold from Robertson?
Your Honor, when I first came in, no, I didn't have a chance to talk to Mr. McLeod, but when I first entered the jail, they actually spoke on the hold and they told me that Robertson County said they didn't want me. So I don't know how the system works from there, Your Honor. But when I got booked in, they told me that Robertson County, they reached out to Robertson County, they said they didn't.
I'm not interested in what they told you because I don't know who they are. And I'm just looking at this and there is a hold.
Okay.
So I'm looking at the documents. All right.
I guess we'll have to get in touch with Robinson County to see whether or not the hold is still active, Your Honor.
That's what you have to do.
And that is what I will do.
Yeah, you did. is right. Violation of probation affidavit from Tennessee Department of Correction. He's got a fugitive hold. So, okay, let me just do this again. So, Mr. Godwin, you've got a fugitive hold. You won't be released within 24 hours. Robertson County in Tennessee will have to come and pick you up or to remove the hold. If they pick you up, then once you are resolved your Tennessee problems, you have to come back to Fulton County and serve out the remainder of your time on probation. I will waive your probation for the first 3 months, and the minute you start probation, you're required to enroll in a domestic violence intervention program and complete all 24-week classes at your expense. You're also to have no further violent contact with Latanya Lowe. So, so I guess you still have a few things to resolve before you can come back to Fulton County probation. The remainder of the time on probation is told. In other words, it's not moving until you get back from Tennessee. And
Yes, ma'am.
they'll welcome you back with open arms. Okay? Good luck. Thank you.
Thank you.
Judge,
Thank
this
you, Your Honor.
probation,
That concludes my business before the court. May I be excused?
Yes, thank you.
Thank you.
was the probation to November or December, Judge?
No, probation is told until he comes back from Tennessee.
No, the waiver.
Oh, the waiver of what? The fees?
Yes.
It's just for 3 months of whenever he reports to probation.
Okay, all right.
Yeah, I thought he didn't have a hold. Okay. All right. Oh, it's 11:05. Oh, then let's see. Paul Dwayne Childs. Paul Dwayne Childs. Vincent Lindsay. All right. No show on our bench warrants. Jail code, who do we have?
He's on the pull sheet, but it doesn't have a position number next to him. Mr. Wiggins?
Wiggins?
Yes, Nicholas Wiggins.
Do you have a case number? Or a booking number?
He's on the competency calendar, Judge.
I see.
Number 8 on the competency calendar.
I see him now, yeah. Mr. Nicholas Wiggins, your attorney is going to be Mr. Paul Bartel. Mr. Bartel?
Yes, Your Honor, I'm coming in a second.
Right there, okay. And would you like to address this in the breakout, or would you like to, is there a reason why we've got him in the main session?
I don't know, Your Honor, but there are no other clients or inmates in the courtroom, so we can address it now.
Okay. Miss Strong, can you put jail court iPhone?
I got it, Judge. I'll do it.
Miss Kasha, if you please start your video. Who else is going to go into the competency breakout?
Yeah, whoever it is, start your video.
Yeah, Ms. Kasha is working on his case, Your Honor.
Okay. All right, I think that's it. Is Miss Mokeke joining us?
I can, Your Honor.
All right. All right, there you go, Miss Lewis.
Okay. All righty, I got you.
Thank you.
Are you Mr. Paul Children? I can't hear you. You're muted. Unmute yourself, sir. You're muted. Unmute yourself.
Okay, you get me now?
Yes, I can hear you now, sir. The judge had already called that counter. They're in a breakout room right now, regarding another counter. You're here for the DV bench warrant to set aside.
No, no, I didn't have a warrant.
No, I'm just saying you're on the BV, you're trying to have your case set aside. Apparently, a bench warrant set aside for a missing court, before Judge, Judge Roth, back in, December 4th of 2023, am I correct? For a battery, simple battery case?
Yes, ma'am. Yes, ma'am.
Okay. The judge will have to address, I understand what you're saying, there's not an active warrant on the system, but they still gotta address the bond forfeiture if they're gonna still set it aside, so you're gonna have to wait till they come back from the breakout room. Just, mute yourself and, I'll put your last name on the screen to indicate that you're here for the, DV counter. Is Mr. Vincent Lindsay also on the line? Vincent Lindsay.
I don't know who that is.
No, I'm calling somebody else. I'm done with you. You can mute yourself and turn off your camera until the judge comes back.
Okay.
Is Vincent Lindsay on the counter? I have an iPhone, but I don't know who that is. Okay. So you're gonna have to wait. They're in a breakout room right now, so you're just gonna have to sit patiently and wait until they come back, Mr. Paul.
Okay, thank you very much, ma'am.
You're welcome. Mr. Paul, I'm gonna stop your video because this is court. You're not supposed to smoke, you're not supposed to drink. So I'm gonna stop your video. If you want to smoke your cigarette, I'm gonna stop your video, okay? Ms. Falk, do you need to go into the breakout room? Mr. Ferguson, who are you here for today? You can unmute yourself. Who are you here for today, sir? Mr. Ferguson, please unmute yourself. Do you know how to operate your phone?
Yes, ma'am. I said Montavious Ferguson. I'm sorry. I didn't see it was still on mute.
And who are you here for today?
Montavious Ferguson.
Are you Martavis Ferguson or are you here for somebody named Martavis Ferguson?
Yes, ma'am. They say he supposed to been in court for the day.
Yeah,
And I
he
was
is
just
in court today. I don't know. I think they already addressed this case. I'm not certain. They're in the breakout room. Are you the victim in the case?
no, that's my son.
Okay, all right. I don't know what happened today because I don't know what the announcements is. When the judge read off the counter, I don't know if they've seen him yet or not. But when the judge come back from the breakout room, they go through the counter. I guess you can find out what happened with his case. But right now, I have no clue right at this point.
Okay, because he just called me like an hour ago and said he ain't did nobody come and get him or something.
Let me see if I can figure out what the announcements are on the case. Give me 1 second. You can mute yourself.
Okay.
Mr. Ferguson? Hello, Mr. Ferguson?
Yes, ma'am.
The announcement on his case was that they waived his arraignment and his case is reset for trial further notice. and they did not bring him to court. So there's a reason why he did not appear today. So they waive his arraignment. He's gonna go to trial on further notice. So his case is going back to the judges originally signed for Judge Roth, and they'll set up a court date for him to appear in person in their courtroom. So right now, his case is reset further notice. So is that him right there?
I can't see him.
That's on the jail iPhone. Is that your son?
I can't see.
Mr. Sidwell?
No,
Okay.
that's not him.
Okay. Well, he's not, your son case has already been dealt with. They're not gonna bring him out. They're gonna wait, they waived his arraignment. He plead not guilty. So his case will be set to go back in front of another judge at another time.
Okay.
And I tell you what date that will be.
Okay.
Okay?
Yes, ma'am.
All right. You're free to go.
Okay.
They're in the breakout room right now, Deputy.
Copy that.
They're in the breakout room. Who do you have right there?
I have position number 41, Mr. Sidwell.
Okay.
All right.
So when they come back out of the breakout room, I let them know that you're here for 41.
Okay.
Okay.
Thank you.
Uh-huh.
All right, Deputy Ghost, you have someone at jail court item? Who do we have?
Yes, I have position number 41, Mr. Sidwell.
Okay,
And also, Judge, one of the DB cases came online also, Mr. Paul.
okay,
Children.
excellent. This is Adrian Sidwell, accused of criminal trespass and 3 counts of battery, 24 CR 6279A from September 3rd, 2024. Mr. Sidwell, you have a right to remain silent. Anything you say in open court, the statements can and will be used against you. You have a right to an attorney, and representing you is Ms. Kim. Ms. Kim, if you could unmute and let me know how we're proceeding.
Plead guilty, Your Honor.
All right. Mr. Sidwell, please raise your right hand. Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge? Yes or no?
Yes, ma'am.
Thank you. All right, Ms. Mokeke, what's the recommendation for Mr. Sidwell?
The state's recommendation for count 1, the criminal trespass, is 12 months to run concurrent with count 2. The recommendation for count 2, the battery, is 12 months to serve 32 days, credit for time served 16 days, balance probated, no further contact with Anaya Hood, Renita Pittman, and Marissa Jones. Stay away from that CVS located at 842 Peachtree Street, Northeast Atlanta. 12 weeks of anger management, 40 hours of community service, and absolutely no firearms during this time. The state's recommendation for count 3 is 12 months to run concurrent with count 2. The state's recommendation for count 4 is also 12 months to run concurrent with count 2. I would ask the defense to stipulate to venue, factual basis, and identification.
If we do stipulate for the purpose of plea.
All right, well, I'll just say.
1, 3, okay.
Waivers, that's all I got.
All right, Ms. Kim, I'm going to ask you just to mute your screen. I'm getting a lot of background. Mr. Sidwell, can you hear me all right? All right. Do you recall when we met at your first appearance?
Yeah.
All right. And do you remember the 3 alleged victims who appeared on the Zoom, the ones at the CVS?
Vaguely.
Vaguely?
Great.
Well, now's the time to remember it clearly. So I'm going to be asking you some questions. And if I find that you're not entering this plea freely, willingly, and knowingly, or if you're just pleading guilty just to get out of jail, I'm not going to accept your plea. I take this case very seriously because I remember the allegations. I remember exactly what those victims said at the first appearance. All right? And if you don't comply with what's required of you, I'm going to have you back in jail very, very fast. You understand, sir?
Understood.
Have you consumed any medicine or alcohol?
No.
And have you understood what's going on in your case?
Yes, ma'am.
Do you remember this incident at the CVS pharmacy?
Yes.
How many victims were there?
Most, like 3.
Are you satisfied with your legal services? Are you satisfied with the services you received from your public defense attorney?
Yes.
And are you entering this plea freely, willingly, and knowingly?
Great. Yes.
Do you admit committing these acts of battery and criminal trespass at the CVS pharmacy?
Yes.
Mr. Well, if you decide that you want to plead guilty to these charges, you would have to give up your constitutional right to a trial. You will not get the chance to go back to a court of law where you will get a chance to have the assistance of counsel, to confront the folks accusing you of these charges, to be able to challenge the evidence and the witnesses brought against you, to be able to have your attorney help you present your defenses and your arguments, and also to make the prosecutor carry its burden to prove all these charges against you beyond a reasonable doubt. Are you prepared to give up these constitutional rights?
Yes.
Are you certain? So you're willing to plead guilty to 3 separate counts of battery and 1 count of criminal trespass because you believe that you did commit these offenses?
Yes.
Okay. How do you plead to 1 count of criminal trespass?
Yes.
I'm going to ask you again. How do you plead to 1 count of criminal trespass at the CVS pharmacy?
Yes.
Repeat.
Yes.
Miss Kim, can you understand what he's saying?
Yes.
Said guilt.
Guilty or guilty?
Yes, ma'am.
Which one is it?
It's guilt.
I think he meant guilty.
I
You
don't
can
know
hear
what
me.
it means. He needs to understand what he's saying. Do you understand what you're saying?
Turn the water on. It's guilt.
Are you pleading guilty or not guilty?
I'm pleading guilt.
Guilty. Can you say the word guilty?
Speak.
Also, does he pronounce it differently?
Yes.
I'm not understanding him. I want to make sure that this young man understands what he's pleading to.
I believe he's saying guilty, Your Honor. Maybe have him spell it.
Guilty.
Are y'all, so y'all are satisfied with the word guilt and not guilty, correct?
He's saying guilty.
Okay.
I'm hearing guilty.
All right. Then it must be my old age. All right. So how do you plead to 3 separate counts of battery? Mr. Sidwell?
Guilt.
Guilty.
Okay. On count 2, the battery charge is going to be, Mr. Sidwell, I'm sentencing you now to the charges to which you pled guilty. Do you understand?
Understood.
This is your sentence. 12 months to serve 32 days, credit for time served 16 days. I don't see any holes in the jail, so you should be released within 24 hours, but you must report to the probation office at 132 Mitchell Street on Monday, September 23rd before 3 p.m. While you are on probation, you are to have no contact with Anaya Hood, Renita Pittman, and Marissa Jones. You're also to stay 200 yards away from the CVS pharmacy at 842 Peachtree Street in Northeast Atlanta. While you're on probation, you will enroll and complete 12 anger management classes. You must enroll in those classes within 30 days of being released. You're also to complete 40 hours of community service, and I want you to begin with 5 hours per month and a minimum of 5 hours every month. And you can do your community service at any nonprofit agency that's not a church and not a school. At no time are you allowed to own or possess a firearm or have a firearm anywhere near you. Do you understand, sir?
Understood.
Within 30 days also, I want you to get a job because you'll be reporting to probation every month and you need to start paying your probation fees. Understood?
Understood.
All right. That concludes your sentence.
Next, Your Honor, we have position number 21, Mr. Henson.
41 was Adrian Sidwell. Is this, can you tell?
This is position number 21.
What's his name?
Henson, last name Henson.
Spell it, please. Spell your last name.
Hinson.
Hinson.
Yes, ma'am.
Oh, position 21. Sorry, I heard 41. Sorry about that. I'm getting old, guys. My hearing's going. Oh, my speaker is going. Okay, thank you. All right, Emmanuel Adonis Hinson, is that correct?
Yes, ma'am. That's me.
Mr. Hinson, you are accused of willful obstruction of a law enforcement officer and simple battery from September 3rd, 2024. Your case number is 24 CR 6276D. Mr. Hinson, you have a right to remain silent. Anything you say in open court, your statements can and will be used against you. You have a right to an attorney, and representing you is Mr. Tom White. Mr. White, how are we proceeding? White, please unmute. How are we proceeding with your client?
It's a negotiated plea, Judge.
All right. Mr. Hinson, please raise your right hand. Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Swear.
Right. Mr. Rhodes?
Yes, Your Honor. As it relates to Mr. Hinson, the negotiation will follow on count 1, time served, 32 days, credit for time served, 16 days. And on count 2, 12 months to serve 32 days, credit for time served, 16 days. The balance to be on probation. We ask that he undergo an 8-week anger management course and no further contact with Mr. Harold McGee. Thank you, Judge.
Mr. White, do you stipulate to the factual basis, venue, and ID?
Judge, we do stipulate, we also ask that you waive some probation fees. He's unemployed right now. He will have to pay for this course and allow him to go non-reporting once he's completed all his requirements.
Any objection to non-reporting, Mr. Rhodes?
Your Honor, the state has no objection to non-reporting.
Okay. Mr. Hinson, have you consumed any medicine or alcohol?
Have I consumed any medicine or alcohol?
Have you taken any medication recently?
Yes, I took Seroquel. I take medication.
And are you still able to understand what's going on in your case today?
Yes, ma'am.
Did you understand the explanations of your attorney?
Yes, ma'am.
Are you satisfied with your attorney services?
Yes, ma'am. And I got a question?
Yeah, could you step back, please? Because I can't see you. Perfect. Okay. What's the question?
I was wondering if I had any hold, like foreign hold.
I don't see any at the jailing screen. You looks like you had a felony matter from 2023, but that got resolved. There was a time served on criminal trespass.
That's correct, Judge. I told him he didn't have any on the screen now, but that doesn't mean that once in a while something doesn't pop up, but we don't see any.
I don't see any holes, missed. Oh, sorry. This.
That's our understanding too, Judge.
Okay. Sorry, I was on my screen just went blank. So let me just.
Oh, no.
Yeah, his felony matter was resolved. Okay, no, I don't see any holes. Do you still want to proceed?
Do I want a receipt?
You want to proceed with this plea?
Yes, ma'am.
Are you satisfied with your legal services?
Yes, ma'am.
Do you want has Mr. White explained to you that if you enter a plea today, you would have to give up your constitutional right to a trial in front of a judge or a jury?
Yes,
you
ma'am.
will not get a chance to go back to court, confront your accuser, challenge the evidence that will be brought against you, to be able to present your defenses and arguments, and have the prosecutor prove the charges against you beyond a reasonable doubt. Are you prepared to give up those rights?
Yes, ma'am.
How do you plead to one count of willful obstruction of an officer and simple battery?
Yes.
On the willful obstruction, your sentence is time served to serve 32 days, credit for time served 16 days. On the simple battery, it's going to be 12 months to serve 32 days, credit for time served 16 days. You'll be released within 24 hours but you must report to probation on Monday, September 23rd before 3 p.m. at 132 Mitchell Street in downtown Atlanta. I will wait.
Is somebody gonna be able to give me the paperwork to report?
Yep. When you're discharged from the jail, you should get all your disposition documents.
And if I don't,
Then you come down to the clerk's office and you ask about your paperwork from the clerk's office at 160 Pryor Street on the first floor. Understood?
yes, ma'am.
Today is Thursday. Probation will expect you on Monday morning, anytime before 3 p.m. that day. While you're on probation, you will complete 8 anger management classes and you must enroll in those classes within 60 days of being released. You're to have no contact with Harold McGee. I will waive your probation fees up to the end of November 2024, and you will start paying probation fees on December 1st, 2024. If you complete all your 8 anger management classes and you are up to date with all your fees, then your probation will be non-repeating.
Yes, ma'am.
Thank you, Your Honor.
We done?
Yeah, we're done. Thank you.
All right, thank you.
Here we go. Oh, man. Come on. All right, next we have position number 31, Mr. Wells.
All right, 31. And that is, did you say 31?
31?
31 is William Long.
Oh, I'm sorry, Mr. Wells, I think it's 51.
51, okay.
Yes.
Okay, yeah. Are you DeMarcus Wells?
Yes, ma'am.
All right, sir, your case number is 24 CR 6270G, accused of theft by taking from September 3rd of this year. Mr. Wells, you have a right to remain silent about the facts of the case. Anything that you say in open court, your statements can and will be used against you. You have a right to an attorney, and representing you presently, Ms. Kim. Ms. Kim, how are we proceeding?
Not guilty, Your Honor. Waiver of arraignment will be filed.
Mr. Wells, your attorney is going to enter a not guilty plea on your behalf and waive arraignment, and your case is going to be further noticed for trial.
All right.
Thank you.
That's it? That's it?
That's it.
Next, we have positions number 12 and 13, Mr. Crane.
This is State versus Ricky Crane. Ricky is R-I-C-K-E-Y. Mr. Crane has got 2 cases in which he's accused of criminal trespass in each case. 24 CR 3809C from June 14th of this year, and 24 CR 6333C from September 6th of this year. Mr. Crane, you have a right to remain silent. Anything you say in open court, your statements can and will be used against you. You have a right to an attorney, and Ms. Kim represents you. Ms. Kim?
Actually, it is Mr. Tom White, but he just stepped out of the courtroom. But it is a plea deal, Your Honor.
All right. Would Mr. White like to be present for this, or would he be back?
He will be back soon. He should be back very soon, Your Honor.
I live with that problem. 13 years. They want to give us the time for work at home.
Mr. Paul went out to find Mr. White. I think he went to the restroom real quick.
All right. Mr. Officer Goff, do we have any other cases Like perhaps from positions 30 onwards, I think those might be Miss Kim's cases.
Mr. White is here, Your Honor.
Perfect, thank you. Mr. White, we are addressing your client, Ricky Crane.
Understood, Judge. This one's 12-13, I got.
All right, it's going to be a negotiated plea. Mr. Rhodes?
Yes, Your Honor. As it relates to position number 12, criminal trespass, the state is recommending 12 months to serve 4 days, credit for time served 2 days, and the balance be suspended. That he stay away from 1030 White Oak Avenue, Southwest Atlanta, and have no further contact with Mr. Peter Utomwen. And I'm going to spell that as Utomwen. And it is a global recommendation to position number 13, which is 12 months to serve 45 days, credit for time served 14 days, and that the balance be suspended. Stay away from 1030 White Oak Avenue, Southwest Atlanta. No further contact with the same victim, Your Honor, that I just spelled the name of. It says here that restitution shall remain open for 30 days. I don't know how that's going to happen if he's not on probation, but from my understanding, he's going to pay restitution, provided it's received within 30 days.
You are chiming in with the very question I was going to ask. How do I keep the case open for 30 days for restitution if the balance is suspended? So the state will have to decide whether this is going to be suspended with no restitution, or is this going to be probation for at least 30 days to address restitution?
And Mr. White, I don't know if you and Shelley Falk talked about this case in particular, but it would be the state's preference that it be 12, at least on one of the cases, that it be 12 months probation. And so on count 2, 12 months to serve 45 days, credit for time served 14 days, the balance be probated, and that he stay away from the address and the victim. Restitution can remain open at 30 days, and upon, I don't see any further conditions upon completing the payment of restitution, I would have no problem with the probation either being suspended or going non-reporting.
Judge, there is no damage to the property. From what Mr. Crane tells me, we would oppose probation. That's not what we agreed to. The owner of the property does have civil remedies if there's damage. At this point, we would ask that you just accept the please negotiate.
Mr. White, when you communicated this offer to your client, with the offer out there, balance suspended, restitution to remain open, what was going through your mind about how that was going to be reconciled?
Well, since this is a suspended sentence, Judge, that means that if he were to violate any of the terms, he could be put back in jail. I assume that.
It's balance suspended. That means his time is done. He's out of here.
Your Honor, a suspended sentence, for example, if he got a suspended sentence, which he is, and he went to 1030 White Oak, the state can have his sentence reinstated. It's a suspended sentence. Now, if we had said straight time served, they could not do that at that point. But on a balance suspended.
So I just want to understand the procedure. With a balance suspended, your client can still be sent back to court to address restitution.
I don't know, Judge, and quite frankly, that's not our concern. Our concern was the offer that was put on the table, we accepted. We did, and it did not.
Your Honor, as the state, I would ask that you not accept the recommendation because I'm reading
the state.
The state would, that you not accept the recommendation because there is still restitution outstanding with the victim that the state is getting together, and that's why it was to remain open for 30 days. If they're not willing to accept probation at this time, For the sake of the victim in this case, I'm asking that the court not accept the plea.
We've already accepted, there's a contract basically in place here.
But the judge has to accept it as well. You do understand the judge, I understand that you might have, it might be contractual.
May I finish my argument?
The judge says that I'm not accepting the plea, then she doesn't have to accept the plea. Do you understand that concept, Mr. White?
I'll let you make your argument. It was my turn to argue.
Yes,
right.
your turn now, Mr. White. It's your turn.
Yes, obviously it is judge's decision, but you make an offer and then you ask the judge not to accept your offer is absurd.
Okay, now it's my turn. I will accept the balance suspended sentence for position 12, which is 24 CR 3809C. And this is 12 months to serve 4 days, credit for time served 2 days, and to stay away from White Oak Avenue involving the victim, Peter Otomwen. Peter Otomwen is not on the Zoom, so I'm not certain if he is, I don't know why he's not here. On position 13, since this case involves the same victim and the same location, and the state is wanting to pursue restitution, I'm going to require it to be 12 months to serve 45 days, credit for time served 14 days, which means that Mr. Crane is still required to serve at least 9 more days at the Fulton County Jail. Would you agree with that, Mr. White?
Yes, Judge.
All right. And during the 9 days that Mr. Crane is still in custody at the Fulton County Jail, the prosecutor shall reach out to the victim and obtain an affidavit as to the alleged damages and have it sent email to both Mr. White and to the defendant at the jail. And this must be done within the 9 days that he's still in custody at the jail. And once that affidavit is received, then the restitution can be made part of the sentence pursuant to the affidavit.
Judge, maybe, I think that is fair. I would request more than an affidavit. We would need some sort of professional estimate to show the damages. I don't want to just take the word. We have an issue with these cases. Mr. Crane actually took care of that property for 13 years. New owners came in.
I mean, he doesn't have to accept the plea. He really
Judge, it sounds like it's not a negotiated plea then. That's what it sounds.
I never said it wasn't a negotiated plea.
No, Mr. Rowe, it is negotiated. I'm just giving the state 9 days to come up with the restitution instead of 30 days. And Mr. White has a valid point that I don't know what items were damaged. So if someone can chime in with that, that would be great.
Well, I'm going to ask the victim witness advocate, Ms. Maldonado, to chime in. We have had contact with this victim. Your Honor, I don't know what the agreement was as it relates to this, but it sounds as if when it says restitution is being open for 30 days, that if it's negotiated, then they have agreed to that whatever the restitution is, that he would actually pay it. If they wanted a restitution hearing, then I believe that the plea would have read that a restitution would be probation and a restitution hearing. And so then to say that they don't agree with restitution when that was a part of the actual plea in position number 13, that restitution would be held up for 30 days and that they would agree to that, then it just seems to me that, it's not in my opinion, it's not a tight recommendation and not a succinct recommendation. So I'm going to ask Ms. Maldonado if we've had contact with this victim and if we're getting that information. The victim advocate in this case.
Judge, you're aware that restitution open for 30 days is basically a hearing because they don't have any proof that there is restitution owed. They are looking to see if there is. That's the whole point. If there were restitution that we knew were owed, that would be part of the sentence.
Well, Mr. White, it could be very well that they're calculating the amount of restitution, not that they don't know that the property is damaged. It could be an issue of the amount.
Okay, listen to this. I'm going to go with my same proposal. Mr. Rhodes, I'm going to accept the plea as communicated, and as you also were clearly perplexed by how restitution issue can be reconciled with a balanced suspended sentence, that's why I'm going to require that the state get the affidavit and an invoice of how much did it cost Peter Otumwan and Fortune Otumwan to fix their door. That's what it was, a front door of the property. Mr. Crane, do you have a problem with that?
Can I say something? Cause I'm the one that knows that they ain't even come to court 2 or 3 times already. There's no
Mr. Crane, Mr. Crane, Mr. Crane, Mr. Crane.
I know.
You're answering the wrong question, Mr. Crane. So what we're going to do is, since he's got 9 days to serve on this sentence, we'll readdress this plea next Thursday. He's already got 9 days to serve. It's not going to prejudice him. This is going to be the same plea offer.
I think that's fair, Judge.
Try to get Mr. Otumwan, 2 people, Fortune and Peter Otumwan. Someone must respond, and this happened on September 6th. I'm sure they've got their front door fixed already. All right?
Here we go.
Fair enough, Judge. Thank you.
This is, both matters are reset to, what's the date? 23rd, 4th, 26th. Thank you.
Judge, so did you want me to put something on this or just reset it, period?
Just reset both cases, period, to complete the restitution.
Okay.
Thank you.
I believe I understand, but just to be clear, so we're not entering pleas today at all. I'm not gonna send over any paperwork for this. We're just gonna do it next whatever, 9 days.
Hang on to the paperwork for Mr. Crane.
Gotcha.
We have position number 42, Mr. Singleton.
This is Shannon Singleton, accused of simple battery family violence from July 5th, 2024, case 24 CR 6338E. Mr. Singleton, you have a right to remain silent. Anything you say in open court, your statements can and will be used against you. You have a right to an attorney, and representing you is Ms. Kim. Ms. Kim, what are we doing for Mr. Singleton today?
I believe it was, give me 1 second, Your Honor, I have to double check. It was basically not guilty, waiver of appearance.
Waiver of appearance or arraignment?
I mean, waiver of arraignment. Your Honor.
All right, Mr. Singleton, your attorney has filed a waiver of arraignment and has entered a not guilty plea on your behalf. Your case is going to be further noticed for trial. Thank you.
And the judge, the victim, was on the line for this case, just want to let you know.
Oh, where is?
It's Natasha Stroll.
She started her video. Lakeisha Waters? Is that her? No, okay. Yeah, Ms. Stroud, your Mr. Singleton has entered a not guilty plea, and the case is going to be scheduled for trial. So you will get a summons from the victim advocate of when to come back to court to address this case.
Okay, can I ask you a question?
Sure.
If I decide to drop the charges?
If you decide to drop the charges, you would need to reach out to the Solicitor General's office, who is the prosecutor, because they have the discretion to proceed with the case or to dismiss it. Unfortunately, it's not your decision.
Okay, but I still want to try.
You can try. Thank you.
Thank you.
Next case.
Next, we have positions number 32 through 34, Mr. Melise.
This is State versus Amid Melise, M-E-L-I-C-E. Mr. Melise, am I pronouncing your last name correctly?
Yes, Your Honor.
Numbers are 22 CR 2647E, accused of criminal trespass. 18 CR 833E, accused of obstruction of an officer and criminal trespass from August 15, 2017. And the third case is 24 CR 6300E, by pedestrian crossing between adjacent intersections with traffic control device in operation, willful obstruction of a law enforcement officer, and criminal trespass from September 5th, 2024. With respect to all these three cases, you have a right to remain silent. Anything you say in open court, your statements can and will be used against you. You have a right to an attorney. Representing you is Ms. Kim. Ms. Kim, how shall we proceed?
Negotiate, Your Honor.
All right. Mr. Melis, please raise your right hand. Do you solemnly swear that the testimony you provide will be the truth to the best of your knowledge?
Yes, Your Honor.
All right, thank you. Ms. Mukherjee?
Yes, Your Honor. The state's recommendation for position 32 trespass is 12 months to serve 8 days, credit for time served 4 days, balance suspended, and a stay away from the Atlanta Food Mart located at 325 Ralph Abernathy, Atlanta. The state's recommendation for position 33, willful obstruction of law enforcement and criminal trespass, is going to be time served 20 days, credit for time served 10 days. The state's recommendation for position 34, for count 1, pedestrian crossing, the state's recommendation for time served 30 days, credit for time served 15 days. For count 2, willful obstruction, it is going to be 12 months to serve 30 days, credit for time served 15 days, 40 hours of community service, and a $300 fine. For count 3, the criminal trespass, the state's recommendation is going to be 12 months to run concurrent with count 2. Stay away from that Greyhound bus station located at 232 Forsyth Street Southwest. I would ask the defense to stipulate to venue, factual basis, and identification.
Yes, we do stipulate.
Mr. Melis, have you consumed any medication or alcohol recently?
No, ma'am.
Have you understood what's going on in all your three cases?
Yes, ma'am.
And are you satisfied with your legal services?
Yes, ma'am.
Are you entering a plea to these three cases freely, willingly, and knowingly?
Yes, ma'am.
And has it been explained to you that if you decide to enter such pleas, you would have to give up your right to a trial in all these three cases?
Yes, ma'am.
You will not get the opportunity to go back to court, to confront your accuser, challenge the evidence that we brought before you, present your own arguments, defenses, and mitigating factors, and also waive your right to have the prosecutor carry its burden to prove the charges against you beyond a reasonable doubt. Are you prepared to give up these rights?
Yes, ma'am.
On position 32, under 22 CR 2647E, how do you plead to criminal trespass from April 30, 2022?
Yes.
Your sentence is 12 months to serve 8 days, credit for time served 4 days, balance suspended. You are to stay 200 yards away from the Atlanta Food Mart at 325 Ralph Abernathy Boulevard in Atlanta, Georgia. You cannot return to that location. Do you understand, sir?
Yes, ma'am.
With regards to 18 CR 833E, how do you plead to 1 count of obstruction and 1 count of criminal trespass from August 15th, 2017?
Yes.
Speaker?
Yes.
Your sentence for each count is time served to serve 20 days, credit for time served 10 days on each count. With respect to your third case, 24 CR 6300E, how do you plead to pedestrian crossing between adjacent intersections with traffic control devices, willful obstruction of a law enforcement officer, and criminal trespass at the Greyhound bus station? How do you plead?
Yes.
On the pedestrian violation, that's going to be time served to serve 30 days, credit for time served 15 days. On the obstruction charge is going to be 12 months to serve 30 days, credit for time served 15 days, balance probated. You will report to the probation office on Monday, September 23rd, before 3 p.m. While you're on probation, you will complete 40 hours of voluntary community service and pay a $300 fine. You are to do at least 5 hours of community service per month, a minimum, and pay $30 per month for a minimum payment of $30 per month until the $300 fine and the community service are completed. With regards to the criminal trespass, is going to be 12 months concurrent with count 2. And there you are to stay 200 yards away from the Greyhound bus station located at 232 Forsyth Street in Southwest Atlanta. That completes your sentence.
Yes, Your Honor.
Thank you.
Next, we have positions 47 through.
Can I do my person? Position number 44 and 45, Mr. Lowry.
All right, Officer Goetz, we'll take a brief pause there at the jail. Is that okay?
Yes, that's fine.
So at medical unit, we have Michael Valler, Valler. Mr. Valler, you have a right to remain silent about the 2 cases currently before you. Anything that you choose to say can and will be used against you in the treatment of your case. You have a right to an attorney, and if you cannot afford one, Ms. Kim will be representing you. Your 2 cases are 22 CR 4277B, in which you're accused of simple battery, and the second case is a bench warrant from September 3rd, 2024. Ms. Kim, how shall we proceed?
Plead guilty, Your Honor.
Right. Medical, please unmute. Mr. Valler, please raise your right hand. Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yes, Your Honor.
Thank you. Ms. Mulcahy, what's the recommendation?
Yes, the state's recommendation for the simple battery is 12 months to serve 22 days, credit for time served 11 days, balance probated, no further contact with the victim, Tawakalit Okunlawan, and to comply with any current mental health treatment plans that are in place. I would ask the defense to stipulate to venue, factual basis, and identification. And upon this plea, we will be null crossing the FTA.
All right, it's got a comment here, non-reporting. What does that mean?
Oh, the probation can be non-reporting.
All right, so, okay. Ms. Kim, are these the terms to which your client has agreed?
Yes, Your Honor.
And you so stipulate?
Yes, Your Honor.
Mr. Valler, have you consumed any medicine or alcohol recently?
No, Your Honor.
Have you understood what's going on in both your cases?
Yes, ma'am. So to my understanding, Your Honor, they told me the bench warrant was dropped. They did tell me that. And they told me that I'll just answer the simple battery and that they'll give me 12 months of probation. I cannot go anywhere near the victim, that means, and they'll release me in 24 upon time served.
You would be correct. With regards to this case, are you satisfied with your legal services?
Yes, Your Honor.
And has Ms. Kim explained to you that if you decide to plead guilty to simple battery, you would have to give up your constitutional right to challenge this case in a court of law?
Yes, Your Honor.
You will not get a chance to be in a courtroom to face your accuser, challenge the evidence brought against you, present your own defenses and arguments, and have the state carry the burden to prove the cases against you beyond a reasonable doubt. Are you prepared to give up these rights?
Yes, Your Honor, I am.
How do you plead to 1 count of simple battery?
I want to take the plea off where I got and like to plead guilty.
Your sentence is going to be 12 months to serve 22 days, credit for time served 11 days. Your jail time is over and you will be released within 24 hours. The remaining time is on non-reporting probation, which means that you don't have to report to probation, but technically you are on probation. Do you understand?
Yes, Your Honor.
All right. While you are on non-reporting probation. You are to stay 200 yards away from Tawa Khalid Okanlawon, which is the name of the victim in this case. You're to stay 200 yards away from him and not communicate with him in any way, form, or manner. You're also to comply with any current MH treatment or counseling that you are currently undergoing. Do you understand?
Yes, Your Honor.
All right. That concludes your sentence. Thank you.
All righty.
And your bench warrant is dismissed. All right. Jail Court Officer Gold.
We have positions 47 through 50, Mr. Waters.
Oh, that's Mr. Water.
All right. What's the announcement for Alante Waters?
Your Honor, I handled those cases. I've met Mr. Waters and advised him of his options. He's pleading not guilty on 47 through 50, and we will send over a waiver of arraignment today.
All right. Mr. Alante Waters, you have a right to remain silent. Anything you say in open court, your statements can and will be used against you. You have a right to an attorney, and your counsel is Mr. Bartel. With regard to the 5 cases that you have presently, I think it's,
It's 4, Your Honor.
4 cases. 21 CR 1066F is for simple assault family violence. 21 CR 1494F is for battery family violence. 23 CR 1022F is for simple battery family violence and simple battery. And 23 CR 8003F is for battery family violence. With regards to these 4 cases, your attorney is entering a not guilty plea to the charges as listed and waiving arraignment. Your cases will be referred to the division judge and further notice to be scheduled for trial. Thank you.
Thank you, Your Honor.
That concludes your cases, Mr. Waters. All right. Officer Gold, do we have anyone else at the jail presently? Okay. Paul Child, if you'd like to unmute and start your video. Paul Childs, if you'd like to unmute and start your video. Officer Gold, do you have anyone else presently?
We had position number 25, Mr. Johnson, but I was just, they just told me that he got moved out of there.
All right. Who has Mr. Kalan Johnson, position 25? All right, we're going to reset that to next Tuesday, which is going to be September 24th.
Which one?
I believe he got moved to South Annex.
South Annex?
Yes.
I don't see South Annex on Zoom.
No, I'm saying, I think he just got moved like either last night or.
Okay. Well, I'll reset it to September 24th, pending his appearance when I'm done with the other cases.
Okay.
All right. Anyone else, Officer Gold?
That's all I have.
All right, sir. Thank you very much.
Thank you.
All right. So Mr. Paul Dwayne Childs is on Zoom. Case number 23 CR 002-7278. Mr. Childs has got a failure to appear in a simple battery family violence case. The charge incident date of the offense is March 16, 2021. Mr. Charles, you have a right to remain silent. Anything you say about the facts of your case, your statements can and will be used against you in the treatment of your case. You have a right to an attorney. If you cannot afford one, one would be appointed to represent you. Who is your attorney, Mr. Charles? Mr. Charles, can
He's
you?
muted.
Oh, Mr. White? Okay.
No, Judge, he's muted. I'm not sure what he said.
He's not muted. I don't think his audio is connected. Mr.
Oh.
Charles, if you can hear me, wave your hand in front of the screen.
Yes, I can hear you, ma'am. It just, for some reason, my volume real low, but I can hear you.
All right, so you've got this particular case, 23 CR 27278. You've got another open case, 24 CR 005799E. And you've got a bench warrant, 24 FTA 001148. And Mr. White, y'all have sought a to set aside the bench warrant on what grounds?
Judge, he never received notice. It was returned to sender.
In which case, this was,
The FTA case.
yeah, November 21st, 2023. And that address was 1342 Willis Mill Road in Atlanta, Georgia, 30311. Is that not his address?
Yes, ma'am.
That's his address, Judge, but it was returned. It never got to him.
Okay,
Your Honor.
Mr. Rhodes?
Yes, as it relates to that in particular, that was his address. That was his last known address. And so that was the address the clerk sent it to. So I would say that the notice was good. So if Mr. White is alleging that the notice was bad, the notice was good because it requires them to send it to the last known address. The fact that it was returned.
It requires it to get to the address. And if it was returned, it didn't get to the address. He can't have actual notice if he doesn't get it. Just because they sent it that doesn't result. It has to get to him. And it didn't get to him. It's clear. It's in the clerk's office. It's returned to sender.
I do see return to sender, Your Honor. I guess what I'm confused about is whether or not it actually ever reached the physical address and it was returned from someone from the physical address.
That doesn't happen.
That being said, I don't know. I guess if it was returned from the post office, then I think that Mr. White would.
May I have screen share, please?
Yes, Judge. Okay, you should have it now, Judge.
Thank you. This is the address it was sent to, 1342 Willis Mill Road, Atlanta, Georgia, 30311. According to the USPS notes, it was returned to the sender. The location was vacant, unable to forward. So if that location was vacant, then it was not a good address, or nobody lives
Does
there.
the post office know it was vacant? There's a mailbox. I mean,
I don't know.
That's what I guess that's what I'm not understanding either. Is how do they even know it's vacant? Because he's saying he's saying today on this Zoom call that is a correct address for him. So I guess that's my issue. How would they have? So I guess if they didn't put it in the mail in the box because they said it was vacant, then I'm inclined to agree with Mr. White. But he's saying that is his address. Are they going to do that again when he received notice?
So this is what's going to happen. I'm going to set aside the bench warrant at the present time. Mr. Childs, I'm going to require you to come down to the clerk's office and check your mailing address. Well, first you should go to the United States Postal Service and verify that your address is correct with them. And then you're going to come down to the clerk's office and you're going to put down your correct mailing address in writing. If it's the same one, that's fine, but I want you to come down and put it down in writing, because the next time that letter goes out and if it comes back the same way, then you have a problem with a defective address that you've provided with the courts, and the next time you'll be writing your change of address while in jail. Do you understand, Mr. Charles?
Yes, ma'am.
All right. Mr. White, please go ahead and submit a proposed order setting aside the bench warrant and requiring Mr. Charles to physically come down to the clerk's office and submit his current mailing address in writing with his signature on it.
Your Honor, if I may, on the motion to set us on the reset notification, it looks like that was done. I'm looking at that at the bottom on dated September 12th, 2024. And it said it was signed by Paul Childs at 1342 Willis Mills Road, Atlanta, Georgia 30311. So it does look like that was done. It even provided an email address of guillotine7@gmail.com.
All right, and that's your correct address, 1342?
Yes, ma'am, that's my correct mailing address.
Well, you better then go check with the United States Postal Service because apparently they think your house is empty. All right, thank you. Next case is Vincent Lindsay. Vincent Lindsay.
I don't think, Judge, excuse me, I don't think he got on the line, but when Mr. White does the order, can he make sure he put the FTA number on the order, which is 24 FTA 001148 on that order, please?
001148.
It's 24 FTA 001148.
All right, thank you.
Thank you.
All right, that's all. And Vincent Lindsay did not appear, so the motion to set aside is denied.
Your Honor, actually, it seems like he is away from state of Georgia and he might be homeless and there's no contact information that we have. So I just wanted to let the court know about that.
Somebody filed a motion to set aside, and if he lives out of state, he can still zoom in. So let me see, bench warrant issued on October 10. All right, well, wherever he's living, if there's a bench warrant, we'll eventually be able to find him that way. So that's sometimes tragically, that's how it happens. Medical, who do we have? Mr. Charles, you're free to go.
Number 37 and 38, Jonathan Rodriguez.
Thank you. And Ms. Kim, is this your client?
Yes, Your Honor, he's pleading guilty.
Okay. This is Jonathan Rodriguez, accused of speeding, reckless driving, improper erratic lane change, and a seatbelt violation from 24 CR 4224E. He's got an additional case, 24 CR 6094F.
That was added in error, Your Honor. He was on SAP on the 12th and already pled guilty to that charge.
So that one's out. And then on position 38, he's got a bench warrant, 24 FTA 1332. So, Mr. Rodriguez, you have a right to remain silent. Anything you say in open court, your statements can and will be used against you. You have a right to an attorney, and representing you is Ms. Kim. Please raise your right hand for purposes of the plea. Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yes, I do.
Thank you. Ms. Mulcahy, what is the recommendation for the traffic charges?
Yes, Your Honor. For count 1, speeding, that is going to be 12 months to run concurrent with count 2 and a $500 fine. For count 2, reckless driving, that is going to be 12 months to serve 50 days, credit for time served 25 days, balance probated, a $500 fine, and a defensive driving course. For count 3, the improper and erratic lane change, that is going to be 12 months to run concurrent with count 2 and a $265 fine. For count 4, the seatbelt violation, that is going to be time served 50 days, credit for time served 25 days. And I would ask the defense to stipulate to venue, factual basis, and identification.
Yes, we do, Your Honor.
Mr. Rodriguez, have you consumed any medicine or alcohol recently?
No.
And have you understood what's going on in your case?
Kinda.
Kind of? Then I'll have to reset your case so that you can talk to your attorney and totally understand what's going on, because kind of is not enough.
Can you tell me?
Ms. Kim, does your client understand what he's doing today? Does he
believe so.
pleading guilty and he's going to go on probation? He needs to pay fines and that he needs to do a defensive driving class. And that if he does not do all that, he'll be back in jail to serve out the sentence.
Yeah, I understand.
All right, so I'm going to ask you again. Mr. Rodriguez, do you understand what's going on in your case so far?
Yes, ma'am.
And are you satisfied? Is it anything else there, or you want to pay attention?
I'm sorry, ma'am. I'm sorry.
Are you satisfied with the services of your attorney?
Yes.
And has your attorney explained to you that if you decide to plead guilty to these traffic charges, that you will not get the chance to go back to court and have a trial?
Yes, she told me.
You will not get a chance to confront your accuser,
Yes.
challenge the evidence that will be brought against you,
Yeah,
to
no.
present your own defenses and arguments,
Yeah, no.
and to have the prosecutor try to prove the case against you beyond a reasonable doubt.
Yeah, no. Yes.
Are you willing to give up these rights?
Yes.
How do you plead to speeding?
Guilty.
Ms. Kim, what is the speeding gap? Or Ms. Mukeki? I'm sorry, you're on mute?
He was going 68 miles per hour in a 35 mile per hour zone.
Okay.
So 68 minus 35,
So-
33 miles over the speed limit.
So that's 5 points, I believe. How do you plead to reckless driving?
Guilty.
That's 6 points, I think. How do you plead to improper or erratic lane change?
Guilty. I'm sorry, ma'am.
How do you plead to a seatbelt violation?
Guilty.
On the speeding matter, your sentence is going to be 12 months concurrent with count 2, and you have to pay a $500 fine.
12 months in where? In jail?
Listen before you ask me any questions.
I'm probation, right? Sorry, ma'am.
Mr. Rodriguez, if you turn to ask the deputy any more questions, I'm going to stop the hearing and I'll see you next week.
I'm sorry.
I'm very serious. If you don't pay attention now, I don't have to take this. On the speeding, your sentence is going to be 12 months probation concurrent with your other charges, and you have to pay a $500 fine while on probation.
Okay.
On the reckless driving, it's going to be 12 months to serve 50 days, credit for time served 25 days. Jail time is over. You will be released within 24 hours, but you must report to probation on Monday, September 23rd before 3 p.m. For the reckless driving, you must pay an additional $500 fine and do a defensive driving class. You must enroll and do the defensive driving class within 60 days of being released. You understand?
Online?
You can do it online, but it is a 6-hour class.
Okay.
On count 3, improper or erratic lane change, that's going to be 12 months probation, concurrent with count 2, and that's an additional $265 fine. And on count 4, the 6th seatbelt violation, that's time served. To serve 50 days, credit for time served 25 days. Your obligation for the seatbelt is done. You have nothing to do for the seatbelt. Do you understand?
Yes.
So you report to probation on Monday, September 23rd before 3 p.m. Probation is located at 132 Mitchell Street in downtown Atlanta.
132 what?
132 Mitchell Street in downtown Atlanta.
Okay, thank you, ma'am.
Your total fine is $1,265. You will need to make a minimum payment of $100 per month to probation in addition to your probation fees. Do you understand?
Yeah. Yeah, I understand.
And you are not allowed to drive unless you have a valid driver's license, adequate insurance, and proper registration.
Yes.
Once you are released, you're going to check with the Department of Driver Services
Yeah.
and to make sure that you have a valid driver's license. You're going to check with the department every month.
Okay.
Because with these many points, I think your license may be suspended. I don't know. You need
I
to
still have my license. I still have it at home.
You need to check with the department every month because I don't know, Miss Kim, have you done the addition? If he has 15 or more points, that license is going to be suspended.
Okay.
All right?
All right.
Okay, that completes your sentence. Thank
And
you.
now, so when do I go home?
Tonight or in the morning?
Within 24 hours. But you go to probation on Monday. Medical, do you have any other cases? All right. While we are waiting on the bench warrant calendar, position number 1, Childs, the bench warrant is set aside. And the FTA case is dismissed, which will be 24 FTA 001148. Position 2, Lindsay, the motion to set aside the FTA is denied, and I'll issue that order. On the add-on calendar for state all-purpose, position number 1 for Brown, Dion Brown is null pros. Position 2, Dion Brown is a plea under the First Offender Act. Position 3 and 4 are null pros. Position 5, Evans, is a waiver of arraignment, further notice. Position 6, Godwin, is a plea. Position 7, Godwin is null pros. Position 8, LeVar Reed, is reset to September 24th. With regards to the state all-purpose main calendar, Ms. Kim, and if we can unmute courtroom 2, there are quite a few announcements that I need to get from the public defense attorneys. Position number 1, Abdul Ali.
Judges, it was waiver. We
Right.
sent over.
Yeah, I'm so sorry. I don't have the announcement list. Ms. Kim, I didn't print that up, but so that's a waiver and further notice. Position 2, Atabug.
It's released, Judge.
All right, thank you. Position 3, Barna is a plea. Position 4, Bennett is a plea. Position 5, Bennett is null pros. Position 6, Charles Bonner.
The waiver, Judge.
All right. Position 6 and 7 are further notice for trial. Position 8, Sean Brown is a plea. Position 9 and 10, Antoine Carter.
They were null pros, Judge.
All right. Position 11, Cheese, is a waiver of arraignment and further notice. Position 12 and 13 is reset to September 26th. Position 14, Ferguson, announcement.
Judge, that's a waiver, Judge.
All right. Waiver and further notice. Ernest Gordon, position 15.
Waiver.
All right. Are we planning to upgrade that to a felony, Ms. McKechnie or Mr. Rhodes, or don't know? I have no, I don't, it says no plea recommendation, so.
Yeah, I believe that Ms. Falk did send it over for one. She's just waiting on approval.
Okay,
And it was reset from the week before, and it's been a week and there hasn't been approval, so we just decided to go ahead and waive it. If they want to upgrade it, they can.
I understand. I just wanted to be sure that it's not been transferred or anything. 16 and 16 was a plea, 17 is null pros, 18 was null pros, 19 was a plea, 20 Harris was a plea, 21 Hinson was a plea, 22 Hogan is a waiver of arraignment and further notice, 23 and 24.
Released, Your Honor.
I'm sorry, Mr. White?
Mr. Ingram was released, Judge.
Released, okay. Released and further notice for 23 and 24. 25, Kalan Johnson is reset September 24th. 26, Courtney Johnson is a plea. 27, 28, Leon Jones.
It was bonded out, Your Honor.
Okay,
Released.
released and further notice for trial. 29, Kendrick is a plea. 30, Danetta Kent.
Release, Judge.
Thank you. William Long is a plea. 32, Melise is a plea. 33 is a plea. 34 is a plea. 35, Elisa Mewborn.
Released.
Okay, further notice for trial. Same announcement for 36, further notice for trial due to release. Position 37, Rodriguez was a plea. 38 was null cross. 39, Sanders is a waiver of arraignment and further notice for trial. Position 40 is a further notice for trial. 41, Sidwell was a plea. 42 was a waiver of arraignment and further notice. 43, Jonathan Smith.
Released.
All right, thank you. Further notice for trial. 44 was a plea. 45 was null cross. 46, Gregory Bond.
Released.
And further notice for trial. 47 is through 50 is a waiver of arraignment and further notice for trial. And 51, DeMarcus Wells is a waiver of arraignment and further notice for trial.
Yes.
All right, are there any questions about any of the cases we've had today? No?
No.
Ms. Strong?
Please send all orders to Ms. Strong on plea orders and all cross orders. Thank you,
Have
Mr.
Have you
Yes.
received any from a Sakani Crawford yet?
I haven't received anything.
Okay, I'll make sure she get them to you.
Who am I receiving it from?
Sakani Crawford.
Oh, no, I haven't gotten anything from anybody. No.
All right, thank you, Ms. Strong.
You're welcome.
All right, everyone, you all enjoy the rest of the afternoon. You all have a good day. Thank you.
Thank you, Your Honor.
Thank you,
Yeah.
Mr. Thank you, Ms. Strong. Take care, everyone.